Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the table. Dati mihi Anglican for his nervous Latino.
Is that correct?
Oh, for Trump's sake.
Literally not true.
I didn't ask you to interrupt me.
Yeah, having sent someone with more experience. I heard that. See what you did there, Tai Chi Lemur. Welcome to the Court of Public Opinion. I am the Recovery Addict. Great to have you here this morning. Good morning to y'all. Apologize for being just a little bit late. I am convinced now more than ever that it is more difficult to start the live stream on this channel than it was to land a spaceship on the moon. It just there is so much involved. I apologize for that. Apology not accepted, says Troy. Fine. I didn't want it anyway, Troy. Thanks. Good to have you here, my friend. Welcome and good morning. Oh my goodness, we're here. That's the important part. We're here, and it's good. All right. Oh man. Let's see. We need to put somebody in charge of the internet. Did you say Mindy? Did we put Mindy in charge of the internet? Is that what I'm hearing? Mindy? Did you do something naughty today, Mindy? I don't need the details. I'm just gonna let me clarify what I'm talking about. Did you speak and break the silence of chat this morning before anyone else? Like everyone was just peacefully enjoying the morning, and you ruined that? Is that what happened, Mindy? Everyone's saying yes. The mods are on. They're on to you. It was working, but yes. That's no excuse. Neither is ignorance of the law, Mindy. Mindy, thank you for being here from the bottom of my heart. I appreciate that. But, and this is a big but you did something, and there are consequences. You, for your promptness and punctuality this morning, which I was not, I'll have you know. I did not set a bad example in this case, but you did. And because of that, we're going to punish you. Everything IP related worldwide, it's your responsibility. There you go. And good luck. And you have to do it in addition to work. Always happy to be here, but there's a big but, always. So that is wonderful. And it is great to be here. It's while you're working, it's got...
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! I'm envisioning the do song coming in from Les Mis when I do that. It's hump day. We made it halfway through the work week. Yes. A little wobble. I was like, who was that? Valger. 2 thumbs up. 7 out of 10. Not bad. Would recommend 7 out of 10. Anyway, this hump day, we made it halfway through the work week. Your sound is too good to be shouting like that. Yes, but it's Wednesday and it needs a celebration. I almost thought it was Tuesday. I had to check last minute to just make sure it was in fact Wednesday. We also need to celebrate by singing a little happy birthday. Thank you, Red Pen, for bringing in the birthdays. Let's get this done and we'll jump into court. We are on catch up. We're on the we're on a case that's going to make us think. Make us wonder and scratch our heads and maybe change our opinions a little bit and be kind to each other. We're on the case of Ebony Parker, a criminal case where an assistant principal is charged in the shooting of a teacher, yet she never even saw the gun. And we'll get into that, about how that works. But we're going to do birthdays and we'll celebrate a couple milestones and we'll get underway. So wherever you are.
Happy birthday. You look good.
Thanks, Judge Fleischer. Thanks for weighing in. Wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. sing happy birthday to Heather Leigh, Miko, and Special K. Happy birthday to you. Happy birthday to you. Happy birthday to Heather Leigh, Miko, and Special K. Happy birthday to you. The high kicks have ponies this time, doing the high kicks as well. Watch out for the hoofs. Flying hoofs, guys. Watch out. Happy birthday to those who are celebrating today. Heather Leigh, Jean Valjean, that's the name. Heather Leigh, Miko, and Special K. I realize there are many wonderful days, but today's your special day. And there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. And the privilege, pleasure, the joy, that is ours. Hopefully we can turn that back to you, make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! Happy birthday. Happy birthday. Now the dancers are going to do their thing for just a minute. Everyone clap on the rhythm. That's what they asked us to do if you're not dancing. I'm dancing, so I'm not clapping. On point is everything. Wow. There we go. There we go. Slot 5. Leading the claps. Wonderful, wonderful birthday celebrations. It's Tammy Dunlap's house still gets me. She moved out of the country, and we still force her to make pancakes every morning. I think she's actually back right now. I think she's back in the States, probably at a hotel where she's making pancakes right now. So if you can find her free pancakes at Tammy Dunlap's hotel. Little chair wiggle. Yeah. Birthday song gets the day going, and then we'll jump right to court, where we are on catch-up. So we're going to be skipping the breaks and zipping ahead, doing the best we can. Join me with the air drum solo for the big finish, though. Ready? It goes like this. Make it snap. Beautiful, beautiful. All right. Happy birthday. Bing, da bang, da boom. And we're done. We're done with that. It was a big finish. It was a big finish. All right. Shall we go to court? Fingers crossed that this works. Yeah, it's been one of those mornings. So let's go ahead and see if we can listen first. See if we can hear them. Do we have court? Not yet. There we go.
Please keep that in mind in deciding whether or not you will take any notes.
We have sound.
At the end of each day, the bailiff will collect your notepads and returns them to you in the morning. At the end of the trial, your notes will be destroyed. The faithful and proper performance by you of your duty is vital to the administration of justice. On behalf of the court and the parties, we appreciate you giving your complete attention to the case as it is presented.
We have some audio work to do, that's for sure.
Defendant like to enter a plea in front of the jury.
Your Honor, she is entering a plea of not guilty.
Okay. So again, Ms. Parker has entered a plea of not guilty, and we are now ready for opening statements. Would the Commonwealth like to give an opening statement?
Yes, Your Honor. Thank you.
Please approach.
On January 6th of 2023, at Rich Neck Elementary here in Newport News, there was one and only one person who had both the authority to take action in a crisis and the knowledge that a crisis was underway. My name is Josh Jenkins. I am the Commonwealth's attorney assigned to prosecute this case. I'm assisted by my paralegal at counsel table, Megan May. And I thank all of you, as the judge has said, for your service. I know it is inconvenient to be a juror, but this case is important to all involved. And I thank you for doing your duty, and I know that you will. On January 6th of 2023, parents of children who went to Rich Neck Elementary and the children themselves woke up to a normal day. They packed lunches, got on the school bus, got in their cars. One walked to school that you'll hear from.
One walked.
And to them, nothing was different that day. And as the parents watched their children, backpacks in tow, walk into that building, those parents entrusted the care of those children to that school. They had a promise that when I bring my child into school, the school will keep them safe. But the evidence will show you that that's not exactly what happened. I understand, and perhaps you understand, that in this incident a teacher was shot. That is a horrific tragedy, and I do feel for Miss Zwerner. But this case is not about Miss Zwerner. This case is about the children who lived through this event in Miss Zwerner's classroom. 20 of them. That's what this case is about. You will hear from that teacher because she witnessed the events. But she is a witness. The victim of this crime are the children. The defendant, Dr. Ebony Parker, was the assistant principal at Rich Neck Elementary at the time. She was the person who was paid to take care of those children. And around 11:40 a.m., Ms. Zwerner had seen a particular child who you will learn has a long history. A long history of discipline issues of which Dr. Parker was already aware well before January 6th of 2023. But Ms. Zwerner observed something about this student that worried her. You're going to hear from her, and you're going to hear what that concern was. And then she's going to tell you that she went to Dr. Parker and warned her that this child, who we refer to as JT, was in a violent mood. You'll hear that she said, "I don't know what I'm going to do if he hits me." That is the knowledge that Dr. Parker had of the history of JT, that and more. But at 11:45 a.m., Ms. Zwerner walks in, tells Dr. Parker that JT is in a violent mood, and Dr. Parker does not respond to her, stares at her blankly for just a moment, and then returns to her work in her office. The warning ignored. You're going to hear that this child's past means that no warning should be ignored. Because you're going to hear from a teacher that taught JT the year before. You're going to hear about the violence that that teacher experienced at the hands of a kindergarten. And you're going to hear about the report that that teacher made to Dr. Parker in that year. And that Dr. Parker's response was blank stare, look back down, do nothing. The same response she had at 11:45 a.m. on January 6, 2023. But that warning was not the only warning. At 12:20, a reading specialist tells Dr. Parker that she thinks maybe JT has a firearm. She says maybe it's a toy, maybe it's real, I don't know. She thinks JT has a firearm. She says, "I'm going to search his backpack." Dr. Parker really doesn't reply to her, but she goes and searches the backpack. Doesn't find anything in the backpack. Meanwhile, there are some concerning observations that are happening on the playground with JT. And you'll learn why teachers and counselors then come to expect that JT has taken that firearm out of his bag and put it into his coat and is carrying it around on a playground full of elementary age students at Rich Neck Elementary School. You're going to hear that he showed it to another brave student, who then reported, young RR reported exactly what he had seen to a teacher. He was terrified, understandably shaken, crying when he reported what he'd seen. At 12:30, that reading specialist goes back to Dr. Parker and says, I think he has the gun in his jacket. Do nothing. His mom will be here soon, she says. I can only imagine how that made RR feel. But around 1 p.m., a counselor goes to Dr. Parker and says, I want to search the child. Can I search him? His person. She says, no. Mom will be here soon. For over an hour, multiple people went to Dr. Parker and told her there was an armed child at an elementary school running around with, interacting with, children in the classroom, children on the playground, children in the hallways. Multiple warnings brought directly to her. She says, do nothing. Does she say, search the child? No. Does she say, call the police, or does she call the police? No. Does she remove the child from the classroom and separate it? No. She didn't even get up from her desk. She didn't even leave her office. Warning after warning after warning, she did nothing. The crisis in this case did not begin with the firing of a gun. The crisis in this case began at 11:45 a.m. when Ms. Zwerner initially warned Dr. Parker that there was a problem. That was the moment Dr. Parker should have left the office and investigated what was going on. There is a moment that will be described to you by a witness on the stand, Ms. Zwerner, where after all that she now knows, all the suspicions that she's now heard, and repeatedly she's heard people that Ms. Kovac and others are going and telling Dr. Parker, she sees JT in the classroom wearing a big coat. She's nervous. And if in an instant she sees him pull out that gun and aim it directly at her face. And before she has a chance to do anything but raise her hand up, JT fires that weapon. It hits Miss Zwerner. At the moment that he fires that weapon, there are 19 children. Right there. And that's why I tell you that this case is not about Miss Zwerner. This case is about the 19 children whose lives were endangered in that moment, but in the moments before as well. Those children were, some of them, between the gun and Miss Zwerner. Some of them, a slight movement of the gun could have hit a child instead of Miss Zwerner. They're right there. Some standing shoulder to shoulder with the shooter. All of them, you'll learn, watched as their teacher clutched her chest and bled before these children, screaming in horror, ran across the hallway to another teacher's classroom, and Miss Zwerner ran to the office and collapsed on the floor. Where, at that point, was Dr. Parker? She had locked herself down in her office. Was the school on lockdown? Not yet. Still no. But a few minutes after Mrs. Zwerner enters the room, a receptionist, Miss Olivera, does finally put the school on lockdown. I commend her for doing it. She should have had to. And it was too little too late. Back in Miss Zwerner's classroom, Miss Kovac has shown up, the reading specialist I told you about earlier. She knows JT. She knows his history. And when she heard that gunshot, she knew exactly what happened. And she went straight into that classroom. She found in that classroom the gun lying on the floor. You'll learn that that gun contains 7 rounds, one of which, 7 rounds plus one that was jammed in the action of the firearm. So 8 that was unspent. Amy Kovac enters that room and she just puts JT in a bear hug as she calls 911. She holds that child there until police arrive. She will tell you that that whole time she was saying, he was cursing. He was saying, explaining that he shot his teacher. And she was saying, like the consummate faculty teacher she is, don't use that bad language, you know better. She's just doing the best she can to control the situation alone in a classroom where a teacher has just been shot. Miss Kovac, the reading specialist, also the one who searched the book bag after telling Dr. Parker that's what she said. A task that I don't think reading specialists are supposed to do in an emergency. And the reason that I don't think that is because school policy at the time said exactly that. RichNet had adopted a crisis management plan. And that plan required teachers and faculty members to report crisis situations to administrators, and it required administrators to take actions. One such policy from the Newport News Handbook, you'll learn, was that in terms of searching a student, that could only be done by an administrator or a school security officer. And at the time of this shooting, there was no school security officer at this building. They shared their security officer with another building, and so the security officer was at the other school. So at the moment of this crisis, there were exactly two people in the building who had the authority under the policy to take action. And those two people were the principal, Ms. Newton, and the assistant principal, Dr. Parker. But let me remind you of how I started today. There was only one person that had both the knowledge of the ongoing crisis and the authority to act. While Ms. Newton, the principal, certainly had the authority to act, she had no idea about any of this. Because Dr. Parker, nor anyone else, bothered to tell her. Ms. Newton, you'll learn, didn't get any of these suspicions that day. She didn't know any of this was happening until there was a gunshot. So she had authority, but no knowledge that there was a problem. It's only Dr. Parker that had both of those things. When you hear from these faculty members, they will tell you that they wish they had violated the policy. In hindsight, there'll be no question. They regret it. They regret following Newport News policy. They will tell you to a person that they wish they had just searched the kid and gotten the gun, or they wish they had just called the police. That's what they say in hindsight. And you know what? I would bet that Dr. Parker also wishes she had done differently. I do. But here's the difference. The policies that were in place enabled, in fact required, Dr. Parker to act. The teachers, on the other hand, and faculty, if they were to act, they'd be acting against the policies that were in place that day. And that is a significant difference. There was only one person in the school that day that had both the authority to act and the knowledge of an ongoing crisis. And that person, you'll see, was Dr. Parker. Many people knew the crisis had begun. 2 people had the authority to do something about it, but only one person had both. During the course of this trial, we are going to mention a lot of initials. We're not saying the names of the children because we don't want to put their names out to let this be their story forever. We're asking everyone that testifies, and all of the personnel will definitely be using initials. I say that because that's going to be a lot of initials. The judge talked to you about taking notes earlier, and it is your choice. These will be distributed to those who wish to take notes here in a few moments. Let me encourage you that almost all of the important evidence in this case is going to come out piece by piece by piece, puzzled little detail by little detail, from several witnesses who will take the stand and testify. And when you go back to deliberate at the end of all of this, all you'll have is your memory and your notes to help refresh your memory. You won't be able to have testimony read back to you, as the court pointed out. And often I've had the experience of jurors deciding to ask a question, which is, what did so-and-so say in their testimony? And they're always told by the judge, we can't answer that question. You have to rely on your own memory. And so I'm just giving you that heads up. We're going to be throwing a lot of initials at you, a lot of details at you. And when the judge instructs you on the law at the end of this process, you'll have to remember all those details in order to decide this case. So I do ask you to really pay attention to the witnesses, and I suggest that you take notes to help refresh your own memory, because at the end you will have heard a lot from a lot of different people. January 6, 2023. 20 students went into Miss Zwerner's classroom, and their lives were forever changed. The trauma that they experienced is unspeakable, and you will hear from some of the parents about that trauma. That shouldn't happen. And the one person who had both the authority and the knowledge that a crisis was ongoing is the reason that it happened. And we think at the end the evidence will show you exactly.
Okay, we're going to pause just for a second. A couple of you have asked a lot of good questions. We're going to catch up with those. This trial is, as you've heard, it's the trial of the assistant principal charged with failure to act. Actually, she's charged with 8 counts of felony child abuse and neglect, is what they call it, or sometimes felony child neglect. 1 charge for each of the bullets in the gun. is what they're charging her with. And you've heard the state lay out the case. We're going to hear a lot of initials. JT is the child that brought the gun. RR saw the gun out on the playground. Then we've got Mrs. Zwerner and Ebony Parker. We've got the reading specialist, Miss Kovac. We're going to hear a lot of these names and many more as this spells out. History on this. We know this happened back in January 6th of 2023, and this occurred. The teacher survived. She did sue the school for $40 million. She won $10 million in a civil suit. It's rare to see the civil suit go before the criminal suit. Usually criminal sort of lays the foundation for the civil. That might give you an indication of how of how strong her case was. But this is going to play out here. So this is in Newport News, Virginia, just north of me, one state. Not far from Amber's stomping grounds, and she might even get to the courtroom for this one as well. So we are on catch-up. This is day one. We're going to be catching up and skipping the breaks and zipping through as quick as possible as we catch up to this. It's going to be a short little trial, but it's going to be interesting. I will tell you up front that I have some biases in this one going in. I have a really hard time charging people or proving a case based on what might have happened, like what could have happened to those kids, or how easily if the gun had turned, it would have hit someone else. I have a hard time with that. I'm more comfortable with charges that address the actual crime, the actual events, instead of what might have been and the what ifs. And I also have a hard time with charges for people for things they didn't do, right? Unless there is a duty, which is implied in this one, both in the policy and everything else. Like if an officer fails to do something, like they have a duty to protect a suspect in their custody, and they fail to do that. That I can see, and here we're sort of getting to the edge of that line where we've got an administrator who is entrusted, who legally is responsible for those children, I think it's okay for this prosecution. I'm not against this type of prosecution in this situation, but anyway, that's sort of my feelings going into this. So we're gonna let it play out here.
Have to give an opening statement.
Yes, Your
Here's
Honor.
defense's opening statement.
May it please the court, Mr. Jenkins, ladies and gentlemen. As you found out yesterday, my name is Curtis Rogers. I, along with attorney prosecuting team, are representing Dr. Amy Parker. Ladies and gentlemen, we have heard that my client, Dr. Parker, is accused of the crime of felony child abuse and neglect. There is one thought that I want you to keep in the forefront of your mind during the pendency of this trial. And that is, based on their actions, there wasn't a gun. Based on their actions, there wasn't a gun. Now, the Commonwealth talks about a lot, and this ongoing crisis, and that Dr. Parker was the only person that had knowledge of the crisis and the authority to act. I would submit that's not accurate. It's not true. And think about it. Who was the one person that was there from the beginning to the end? And that was the teacher, Miss Zwerner. Okay.
The victim?
Based on her actions, she did not act as if there was a gun present. So if she thought that there was a gun present, then her actions should have been to separate the child, in this case JT, from his classmates, or separate the classmates from JT. She didn't do that. There was also another person that had suspicions, and that was Amy Kovac. Okay, if she thought that there was a gun, she had the authority to separate JT from his classmates, or initiate a separation of the classmates from JT. That did not occur. The Commonwealth mentioned that JT was out on the playground with his classmates, and there were teachers, agents of the school, that observed things that were going on. He said that caused them alarm. But based on their actions, they did not respond as if there was a crisis or danger to those students. They did not separate JT from his classmates. They did not separate his classmates from JT. So, Commonwealth is saying that only Dr. Parker had authority. Each one of those individuals had the authority to remove those classmates or to remove JT if they thought that those students were presented with any kind of threat or harm or danger. We're at the beginning of this trial, and I need you to understand that right now, Dr. Parker stands presumed to be innocent. Right now, she's innocent. The Commonwealth has to prove beyond a reasonable doubt that she's guilty of the allegations that they are presuming. The Commonwealth has to prove that Dr. Parker was a guardian or other person responsible for the care of the alleged victims. Before Dr. Parker, there was the teacher, Ms. Zwerner. And the Commonwealth has to prove that Dr. Parker's willful act or omission in the care of the children was so gross, wanton, and culpable as to show a reckless disregard for human life. Who was the person that saw these events from beginning to end? That was the teacher, Ms. Zwerner. Who was another person that pretty much saw everything before Dr. Parker was? That was Amy Kovac, the reading specialist. There was another person that saw everything from definitely before the shots were fired, and that was Mr. Ross. If the Commonwealth wants to accuse Dr. Parker, what about these other people that had direct contact with this child, JT? It is my belief that the Commonwealth will not be able to prove beyond reasonable doubt that Dr. Parker is guilty of these alleged crimes. And I will be asking you at the conclusion of this trial to find Dr. Parker not guilty. Understand, I need you to always consider it. Based upon their actions, there was no crisis. There was no gun. Based upon their actions, there was no crisis. There was no gun.
Thank you. All right, the bailiff is going to offer you notepads, and then we're going to try to push forward with the first witness. This is the jury handling a break. Okay. And you don't have to take notes, but if you'd like so, we'll distribute notepads. While they're doing that to the attorneys, we did not swear witnesses en masse, but we'll do so as they're brought onto the bench. Is that acceptable?
Yes, it is.
Okay. And is there a motion regarding witnesses?
Motion to separate notes. We agree.
Okay. So order. And I'll allow the attorneys to know who their witnesses are and make sure there's the question.
The audio is so bad here in this court. Everything is mic'd except for the people. We've got notepads with microphones. We've got desks with podiums with microphones. So we're going to hear people like tapping the lectern. Footsteps are clear as day. But sound is anything but good. I'll do what I can for you guys.
These notepads are the only pads that you'll take your notes in. Private or personal. Okay. That's it.
Just summarizing what the defense said in their open, they basically said the teachers are to blame. They're the only ones who knew what happened from start to finish. They're the ones who thought there was a gun. They should have done more. That's a quick way to erode morale in a school district, I can tell you that. Tisha, thank you very much for the sunshine. Miss Warner is going to be our first witness. She's the one that first told the assistant principal about the violent mood that she observed in JT. JT, the student, too young to charge, not charged criminally. How many jurors would convict a 6-year-old? Abigail Zwerner. I'm calling her Warner. I think it's Warner with like a Z. But the Z might be silent. First witness and the victim, who the defense sort of threw under the bus in their opening statement, saying she was the only one that knew really what was going on. She was there from start to finish.
Good morning, ma'am. If you stand right in front of Madam Clerk to be
Where's the right hand?
Do you swear or affirm the testimony you're about to give is the truth, the truth, and nothing but the truth?
Put that on.
You have to put this in.
Watch this. Yeah, second. Take a look.
You can adjust the chair or microphone to answer questions the attorneys may have. You may proceed, Mr. Speaker.
Good morning.
Good morning.
Could you please tell us your name?
My name is Abigail Zwerner.
Ms. Zwerner, I know we talked about this before, but just as a quick reminder, we're not using the names of any children today, okay? I want to ask you, back in January of 2023, how were you employed at that time?
I was working at Richneck Elementary School.
And what did you do there?
I was a first grade teacher.
And is Richneck Elementary School a school that's here in the city of Newport News?
Yes, it is.
How long had you been teaching as of January 2023?
That was, at that point in time, I had been teaching for 2.5 years.
Okay. You've told us that you were teaching first graders. Roughly how old are first graders?
Around 6.
And how many students, I'm asking only for a rough estimate, but how many students were in your class roughly?
Around 20, maybe more, maybe less.
Sure. I want to talk to you about one particular student who I've identified as JT. Do you know who I'm talking about?
Yes.
On a couple of days before January 6th, was there an incident with JT in your classroom?
Yes, there was.
Now, JT, was he a student in your class regularly? He was your homeroom student?
Yes, he was.
Okay. And so a couple of days before, what incident happened with JT?
On that Wednesday, the student had gotten a hold of my cell phone and he had slammed it into the ground.
And can you describe, if you remember, just his demeanor or behavior in the moments before that happened, leading up to it?
He was defiant.
Objection?
There's objection.
What's the objection?
His demeanor 2 days before is relevant to what happened on January 6th.
Objection is demeanor 2 days before is not relevant.
Testimony will reveal that this was reported to Dr. Parker, so it goes to her knowledge.
Overruled, which means you all can consider it. You may proceed, Mr. Jenkins.
So I had asked about his demeanor in just the moments that led up to the phone.
Yes, he was being defiant, saying no back to my directions.
Okay. And so how did he get your phone, if you know?
It was our small reading group time, and my phone had rang across the classroom, my school phone. And when I had gone back to my small reading group table, I saw him with my cell phone.
Okay. And what was he doing? Do you remember how he looked at that moment?
Just very defiant, almost kind of a challenging face.
Okay. After he broke your phone, do you do something about that for him to try to get a consequence, or what happens?
Yes, I immediately bring him to across the hall to my lead teacher, Miss West's classroom.
Okay. And do you know what Miss West did from there? If you don't know, that's all right, but if you know.
I recall that I asked her to use her walkie-talkie to ask for help.
Okay. And do you know what, if anything, what happened to JT as a result of him smashing the phone?
No.
Okay. Was he at school the next day?
No.
And then did he come to school on January 6th?
Yes.
Okay. I want to talk to you then about January 6th of 2023 then, starting in the morning, maybe lunchtime. Did you have some observations about JT at lunch?
I did.
And before you go on, did you end up reporting those observations to Dr. Parker?
Yes.
Okay. Would you just sort of describe to the jury what it was you saw that you ended up reporting?
Yes. Two things had stuck out to me. At the beginning of lunch in the cafeteria, we were standing in the lunch line, and I was approached by another teacher that the student had threatened to beat up one of her students. And so I...
Your Honor, objection?
Yes, sir.
Sounds like she is testifying as to something somebody else told her.
That's called hearsay.
Okay, so objection, speculation, your response.
Oh, I heard a hearsay objection. Is it a hearsay?
Objection.
So, to the extent that it's a hearsay objection, we are not offering this for the truth of the matter asserted. The statement is to show Dr. Parker's knowledge of what was told to her, not whether it's true or not.
Sustained. So I think it's impermissible hearsay. I'm not sure what exception it falls under. Do you have an exception?
Well,
this judge,
it wouldn't be hearsay if they're not offering it for its truth. So I'm
not for the truth.
Relevant?
It's relevant because it shows Dr. Parker's knowledge.
Which goes to an element of the case.
Yes.
And therefore it has to be reliable. So what hearsay exception is that? Or what case law do you have? What authority allows that to come in?
What?
Judge, if it is hearsay, if the court's ruling is that it is hearsay, it does not come in.
Okay, and hearsay. So you all cannot consider that. Next question.
Thank you, Judge.
Thank you.
So, Ms. Zwerner, I'll back up a little bit. You mentioned that you were were you personally in the cafeteria?
I was.
Okay. And was there anything you personally observed about JT that concerned you?
Yes. I was speaking with a security officer in the cafeteria about something, and at that same time, I witnessed the student was staring her down, very focused on her, and he slowly got up from his seat and ever so slowly approached, still not breaking focus or eye contact at the security officer, and that stuck out to me a lot as well.
Okay. And is it fair to say that you do go to Dr. Parker to report concerns?
I do.
And without telling us what anyone else said, did you relay to her concerns that you had, about things you had observed and concerns about that had been told to you by others?
Objection, Your Honor.
Third objection.
I don't know what the objection is.
That would be hearsay also.
Did you observe?
Hearsay also.
She's reporting what she observed. The report is hearsay. It's out of court statement, out of court truth.
Okay, your response, Mr. Chairman.
I am only offering that she informed Dr. Parker of her concerns and that her concerns were based on both her observations and what others had told her. I am not eliciting what others said to her at all, so it's not hearsay.
Not the statement, just the, okay. So overrule, ask your question again. You may answer.
All right, so Ms. Zwerner, Did you eventually go speak to Dr. Parker about your concerns?
I did.
And did those concerns include both your observations and what others had said? Don't tell us what the others said, but just did your observation, did you report to her the problem?
Yes.
Okay, tell us what you reported to Dr. Parker.
Your Honor,
now you can't.
I'm going to continue my objections because his question was what she observed and what others said. Now he's going to ask her what you reported, and so she's reporting, sounds like hearsay.
Response.
Judge, she is reporting to Dr. Parker concerns she has based on a totality of things that include what others have said to her. I'm not eliciting what others said to her. I am eliciting what she told Dr. Parker. That is what the testimony is. So this is not hearsay. I am not offering the statement of those individuals at all. Even if I was, I wouldn't be offering it for its truth. I'm offering it for Dr. Parker's reaction to her response. So it is not being offered for its truth. It's being offered for her state of mind.
So I'm going to sustain in part and overrule in part. Again, if the hearsay can't come in through the front door, it then cannot come in through the back door by her saying, well, this is what I told her based upon what other people told me.
Okay, so that's sort of good.
She can answer your question as to what she told Dr. Parker based upon her personal knowledge and personal observations, but she cannot relay what she told her based upon what other people told her. So you can proceed that
I'm okay with that ruling.
I don't know any other way to ask this, but what did you tell Dr. Parker?
I told her specifically that the student seemed to be off already that day and in a violent mood.
Okay.
Okay.
At some point during the course of the day, did anyone suggest to you that that same student, JT, might have a gun?
Yes.
Objection, hearsay.
That's not hearsay.
Okay, objection, hearsay, and maybe foundation. Your response, Mr. Jenkins.
So first of all, that also is not being offered for its truth. We're not offering it to prove that JT had a firearm. We're offering it to prove that someone informed her of a danger, so it's for her response.
So can you lay a better foundation as to how she would have this knowledge?
Sure. During the course of the day, did you become aware that a child was armed?
Yes.
And is that because someone told you the child was armed?
Yes.
Who told you that?
Our reading specialist, Amy Kovac.
Your Honor, I'm sorry. I was distracted. He asked two questions when I did not hear what those questions were, so I want to make sure that I understand what the questions were. So,
Okay, Mr. Jenkins, if you would, please.
Can you pay attention this time?
Did you ask your co-counsel?
we were actually talking. So.
Okay.
We were having our own little sidebar.
He was armed, and who told you?
Okay. Objection, hearsay.
There it is, 6.
Okay. Overruled. Go ahead.
This is nuts. We need a hearsay class in Virginia stat.
At that point, what was your state of mind as to...
So that was the question. I did not hear what her response was to that question.
She said Ms. Novak told her. I've got your objections on the record. Overruled. Start your question over again, Mr. Jenkins, please.
Oh, my goodness. Oh.
I believe you said, what was your state of mind?
Yes. What was your state of mind as to concerns about that being shared with the administration? Were you going to go share it?
Was I? No. Ms. Kovac went and told administration.
And
objection, hearsay.
Continued objection noted. You may proceed.
And as to that objection, it is overruled, Judge.
It is overruled. Yes,
Thank you.
May proceed.
Were you concerned enough to keep a close eye on JT?
Yes.
Tell us about your observations going forward from there.
Specifically what point in time?
Yeah, so at some point, do you end up, your class goes to recess?
Yes.
Are you there?
Yes.
Okay. What did you observe at that time, if anything, that was concerning?
Yes. I noticed that the student was wearing an oversized jacket with both of his hands in his pockets that remained in his pockets the entire time.
Okay.
And that stuck out to me.
Okay. Did you report that observation to anyone?
I texted Amy Kovac that observation.
Okay. After recess, did there come a time when JT and your whole class and you were back in the classroom?
Yes.
And did you observe anything that concerned you when you're back in the classroom that day?
Yes.
Tell us what you observed back in the classroom that started to concern you.
Specifically.
So did you observe JT doing anything that made you concerned after recess time and you're in the classroom?
I went up there to leading the witness.
Did you observe anything concerning?
Judge, if I may respond to that.
You may respond.
So a closed-ended question where the witness can answer yes or no is not inherently leading.
We're in class
A leading
again.
question is one that suggests one of those two answers is the right answer. I am merely trying to direct the witness to where and when I'm talking about. So in another sense, it is just a preliminary matter. I am not, trying to use it to get a specific answer from her.
Anything further, Mr. T?
Yes, Your Honor. And I think he's actually been leading for quite a while.
He has, but you didn't check him out this one, but this one wasn't leading, so I'm going to allow it overruled. But some previous ones were leading, so we'll try to contain that. Do you, the witness, do you need him to repeat the question?
Yes, please.
Okay. I just want you to describe any concerning observations about JT that happened in your classroom after recess.
If any.
If there are any.
Both hands remained in his pocket, his oversized jacket the entire time.
Was he wearing the jacket in your classroom?
Yes.
Okay.
Did not remove it after recess.
Okay. So, Ms. Zwerner, at some point in the day, were you injured?
Yes.
Tell us what immediately precipitated that. Describe it for us.
It came to where I saw at the corner of my eye, my peripheral, the student had. I saw the student looking at me. I looked over. A gun was pointed right at me. He was holding a gun, the student, and was pointed right at me, and then I was shot.
And where on your body did a bullet strike you, if it did?
It went through my left hand and into my chest.
What did you do from there?
I recall the children were getting out of the classroom. Miss West was across the hall. She opened her door and was helping the students. And I went to the office.
Okay. At the moment the gun is fired, and I am asking you to estimate how many children were in your classroom. I'm not asking her to speculate about it. I'm asking her to give us a range that it could have been at the time. She doesn't have to guess. She was there.
Overruled. answer.
I would estimate, I would say it's most likely the same as before, but estimate on the lower side, I was missing a couple of students that day. Around 20.
Okay, thank you. You've described the moment where a gun is pointing at you. At that moment, are there any children in your field of vision?
Yes.
Could you describe that?
It's in, the time is in the middle of class, in the middle of a small reading group. So I have students nearby, I also have students at their desks, I have students very close.
Were there any students that were within inches of JT?
Yes.
Were there any students that were between you and JT?
I don't recall.
Okay. May I have a moment, Your Honor?
Yes, sir.
That's all the questions I have for you now. Please answer any questions from defense counsel or the judge.
If I may?
You may.
Thank you.
All right. Finished messing with the objection counter. We're up to 9 already, and we've got the first witness on the stand.
So basically, JT was in your class on January 6th, is that correct?
Yes.
Okay. You reported that he was a little off the chain, being a little violent that morning, is that correct?
He appeared to be off and seemed to be in a violent mood.
A little violent.
And you had some contact with Ms. Kovac, is that correct?
Yes.
Okay. And you had contact with Ms. Kovac before you went out to the playground for recess, is that correct?
Yes.
Okay. And on direct, you said that Ms. Kovac told you that JT was armed, is that correct?
She told me that the student had told other students that he had brought a gun with him.
That wasn't your testimony on direct. You said that Ms. Kovac told you that he was armed. That was your testimony, is that correct?
Here today?
Yes.
I said that. No, I'm sorry if I said that. I was specifically told that he was telling other students that he brought a gun with him.
Your Honor, sorry. So now I'm going to.
I might have heard a question. I might have heard the question a little differently in my mind.
I know this is a cross-examination, but I'm going to renew my objection to that response because clearly
you asked the question.
Now she's referring to hearsay, and I'm going to ask that her answer to Mr. Jenkins be struck.
Okay. At this time, we'll have a response.
Your Honor, this information is being used to show why Ms. Zwerner took the action she did.
For the effect on the listener,
not being
which is an
offered
exception
for
to
its
hearsay.
truth. And hearsay is only hearsay if we're offering it because the statement made is true. So it explains the actions that she took. It is impart a present sense impression if the court is going to rule that it's hearsay, because she's describing a condition that's occurring right now while it is ongoing, and it is being offered to show how they respond to it. Counsel is objecting to me eliciting hearsay and then standing up and eliciting hearsay. And she gave a short answer to me because we were narrowed by the hearsay objection. She was explaining it more fully to counsel now because he asked. So he elicited the hearsay this time. So
it's not hearsay.
He can live with that. The rule is that hearsay is an out-of-court statement being offered for its truth. We're not offering any of these statements to prove that JT had a gun. We all know he had a gun. We'll have that testimony. We're offering the statements to establish why these people took the actions that they took. That's it. That's not being offered for the truth.
Anything else, Mr. Brown?
I will submit, Your Honor, it is exactly being offered for its truth. Her statement, which I just basically just wanted to clarify, her response to his question, she said he was armed. And she wanted to further elaborate. Her elaboration, had she elaborated during the first question, I would have objected. Clearly, hearsay, she's repeating something that somebody else told her, hearsay upon hearsay, Your Honor, and it's definitely being offered for its truth, because there would be no need to respond if there was not a gun.
So for consistent and clear ruling, again, it came in before, I'm going to allow the statement in. This is a classic example of why we have cross-examination, and all three attorneys are wonderful attorneys who will flush this out for the jury, and we can have an instruction later, again, that it is not for the truth of the matter, but to explain why the person did what they did. So again, you may continue with your cross-examination, and the jury can consider the responses, ultimately the ruling. The current objection to exclude it based on hearsay is overruled. Please proceed with your cross-examination.
Thank you, Your Honor. So, based on information that you received from Ms. Kovac, you believed that the student was armed. Is that correct?
It crossed my mind, yes.
Okay. So it crossed your mind that he had a gun. Is that correct?
When I was told what I was told, it was possible.
Okay. So if he was armed, that presented a danger to your students. Is that correct?
Yes.
Okay. So you took no action to separate JT from his other classmates. Is that correct?
Yes.
All right. And so you allowed him to go out to recess with the understanding that he may have had a gun. Is that correct?
Yes.
You could have refused to let him go to recess. You could have removed him from the presence of his other classmates. Is that correct?
In hindsight, yes, I could have.
Okay. And then you allowed him to return to your classroom with the other students. Is that correct?
Yes.
Okay. Nothing prevented you from excluding him from the classroom. Is that correct?
Yes.
Okay. And nothing prevented you from actually taking JT out of the classroom and taking him down to the administrative office. Is that correct?
Yes.
Okay. So on Wednesday, JT was being disruptive, and you did take him out of the classroom. Is that correct?
Yes.
Okay. And you also alerted administration. Is that correct?
Personally, no.
Okay, but you took steps to make sure that the administration was notified. Is that correct?
Personally, no.
You did not take any steps to make? Okay. All right. You would agree that the potential that there's a firearm in the classroom is a lot more serious than JT breaking a cell phone. Is that correct?
Yes.
All right. You didn't, once you became concerned, aware of a potential there being a firearm in JT's possession, you didn't personally let the administration know that I believe that he has a gun. Is that correct?
Correct.
Okay. You personally did not call the police. Is that correct?
Correct.
You personally didn't ask anyone else to remove JT from the classroom. Is that correct?
Correct.
You would admit that the person that has the first responsibility to protect the students in the classroom is you as the teacher. Is that correct?
Correct.
And you would admit that you did not take any steps to protect the students from JT, in your words, potentially being armed with a firearm. Is that correct?
I would not admit that.
Okay. What actions did you take to protect the students from JT having a firearm?
This might cross the rules of hearsay, I'm unsure. But from the knowledge that I had that day, I was aware that she was told by
I'm
other
talking about what you did.
Absolutely.
What actions did you take?
Absolutely.
All right. Your response is absolutely?
I'm sorry, what was the question? The full question?
Okay. What actions did you personally take to protect the students in your classroom from JT being potentially armed?
I trusted my colleagues.
Okay. All right. Can I have a moment?
You may. And while we're doing so, the juror right under that skylight, if you want to move to the empty seat, you can. I apologize. If you're okay to stay, there's nothing I can do about it.
Thank you, Your Honor.
Okay.
I'll get it out.
Okay, all right. I just want to let you know if there is an empty seat, if you'd like to move.
Well, let me ask, Your Honor, if you ask the defendant's counsel to speak a little louder.
Speak a little louder. We can do that. Thank you. And if you follow instructions, yes, if you can't hear it, let me know. We can fix that. All right, Mr. Rogers, you heard that instruction.
I did.
Project.
My apologies. I'm a soft talker. So, all right, Your Honor, that's all the questions I have for this witness.
Thank you. And you read it back. Yes, Your Honor.
Audio is terrible.
Just briefly, Ms. Zwerner, while you were at recess, were you observing the student closely?
Yes.
Did you have a belief about someone at that time, while you're at recess, going and reporting the issue?
Objection to leading, Your Honor.
Okay, response.
I said, did she have a concern? It is a yes or no question, but that does not make it leading. I'm not suggesting that the answer would be yes or no.
It does actually suggest the answer.
Can you flesh out the objection of what part of the question is leading?
What I heard him ask is, did you have an understanding that someone had gone to speak with Dr. Parker while she was at recess? I mean, I think he's leading her testimony there.
That is a bit.
And what was your question again, Mr. Jacob?
Did you believe that while you were at recess watching, do you believe that someone was reporting what you were seeing with JT, the concerns about JT?
And that's the question that you're objecting to leading?
Yes, Your Honor, because she has not testified to any such thing, and so he's leading her to it, and actually trying to testify on her behalf.
Okay.
That should be sustained.
Overruled, I'll allow it, but there may be another objection coming because we need to establish foundation for this belief. Okay, but go ahead for now, Mr. Jenkins, I'll give you some leeway.
You should have said,
Have you told someone that there was an incident that should be reported to Dr. Parker?
Your Honor.
Hearsay objection.
So,
okay, and I understand. And Mr. Jenkins saying, well, how can I lay my foundation if you keep not letting in the hearsay? I'll allow it. Go ahead. It's not for the truth of the matter asserted. It's to explain the actions of why the person takes the actions that they take. Go ahead, Mr. Jenkins.
Ms. Zwerner, I'm not even asking what you said. I'm merely asking, did you report concerns to another person about JT around the time of recess?
I did directly to Amy Kovac.
Overruled. Go ahead, repeat your answer. So he asked you, did you report? What was your answer?
I did directly to Amy Kovac.
And then did you continue to watch JT?
I did.
Okay. What was your understanding of the teacher or faculty member role in the event of an emergency or crisis at that time?
My understanding from it was being brought up to administration. I'm not sure how much what sentence to put that in when
Ms. Zwerner, are you worried right now about the rules of evidence and hearsay?
Yes.
Because, okay, I don't want you to worry about that. The judge and the lawyers will worry about that, okay? You don't have to. All you need to do is give an honest answer. So I'll repeat the question. Okay. What was your understanding of a faculty member's role when you learned of a crisis? What was your understanding of what you were supposed to do?
report it.
Okay, great. Thank you. I don't have anything further, Judge.
Recross?
Just,
Yes, sir.
but it was also your understanding as a faculty member or teacher that you were responsible for the safety of your children. Is that correct?
Yes.
And that if there was a threat of danger to your student, you were supposed to remove that danger or threat from the presence of the student. Is that correct?
Yes.
Thank you.
Anything else for this witness?
No, Your Honor.
All right. And does she need to remain or maybe she be excused?
Your Honor, we're asking that for all of our witnesses, we're asking they be constructively sequestered, told that they need to not discuss the case with anyone, and potentially be recalled, but to be able to leave the courthouse.
Just a blanket?
We've also, she's been up from the defense, and we've asked that she remain.
Judge, if I may address that.
Okay.
We have many witnesses here. We don't need to keep them here for all 3 or 4 days. I've told all of the witnesses they're subject to being brought back to court, and I have all of their phone numbers. And if Mr. Rogers wants them to come back, I will cooperate and ensure that they are back here and provide any contact information that's needed. But I don't want to keep people here for 4 days if they don't have to be.
Understood. So almost agreeing to them remaining sequestered, but that they can leave the building and they're on call to be brought back. Your position?
That's fine.
That's fine. Okay. All right. So Ms. Warner, those are your instructions. You may step down from the witness stand. You may leave the building, but you may not discuss the case until this trial has concluded. And they have your phone number, so they'll call you when we need you to come back. All right. Thank you very much. Okay, and we've been out for about an hour. Can we take maybe a 10-minute break, and then we'll start with the next witness?
Yes, Your Honor. Thank you.
Okay.
All right.
And let me see, it's 10:49. We'll
Yeah, we're gonna skip the break here a little bit. I guess now is as good a time as any to tell you that just for no reason whatsoever, Virginia does not require you to go to law school to be a lawyer. If you can cram and pass the exam, you get your card. I'm just sharing that for no reason whatsoever, not particular reason. This state is, this is nothing different. I just came across this information, and I thought now would be a good time to tell you that. This is true. Virginia is one of the only few states, along with California, Vermont, and Washington, that allows alternative path to the law reader program, also known as reading the law or legal apprenticeship. This allows qualified individuals to prepare for the bar exam through supervised study instead of earning a JD from an ABA-approved law school. So, hearsay, guys, hearsay. It's a thing. It's real, but we have to know what it is, and we have to understand what the exceptions to hearsay are, and then be able to recognize them in court. That's where we're at, people. Give me a second to skip through this break. Trust me, we are going faster than real time. Man. Hearsay objection. What did you tell someone? Objection, hearsay, that was an out-of-court statement. I'm like, it was her statement. Did someone... Oh, my goodness. Good stuff. Good stuff. We're already up to 13 objections. Unlucky, but that's where we are. Why is it not coming back? Okay, hang on. Probably because I messed it up. Trying to time everything to get everything synced up. Give me just a minute. Small price we pay on the replay to get caught up. All right, there we go. Ready, steady, and go. We're on 6, right?
Parker, all counsel are in place as defendant. We're going to bring the jury back out. Please, Sheriff. Thank you.
We are bringing the jury.
Please stand for the jurors. Jurors in the box. You may be seated.
We're going to resume testimony. It's around 11 a.m. And for parties time-wise, I probably will try to break for lunch around 1. Okay, so we're going to keep going until 1, but if anybody needs a break, I don't mind. We'll take a break. Just let me know. All right, next witness.
Commonwealth calls Amy Kovac.
Okay. Amy Kovac, and I'm saying
K-O-V-A-C.
Thank you.
Kovac is the reading specialist. See how this goes.
Stand here, face the clerk, raise your right hand.
Do you swear or affirm that testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you.
You're looking up on the second. You watch this step now.
Good morning. If you can move the microphone if you need to. Okay. And please answer questions the attorneys may have.
Okay.
Good morning. Could you please tell us your name?
Amy Kovac.
Could you spell your last name for us?
K-O-V-A-C.
Thank you. Ms. Kovac, how are you employed as of today?
I work with Newport News Public Schools as a reading specialist at Newsom Park.
All right. And then I want to take you back to January of 2023. Were you also a reading specialist at that time?
Yes.
And where were you working?
Rich Neck Elementary.
How long have you been employed as a reading specialist total?
12 years total.
During your time at Rich Neck, did you know a student, and I'll remind you that we're not using any student names, so please keep that in mind, but did you know a student by the initials of JT?
Yes, I did.
How did you come to know JT?
Dr. Parker at the time had put him on a modified schedule, and I was his one-on-one teacher for reading during that scheduled time.
Okay. Do you know from your own observations and interactions why JT was on a modified schedule?
I had heard he had... I was on the modified...
Hold on one second, let's go back one. And how this works procedure-wise is they object, the other party gets to respond, and then I'll make a legal ruling, and then I'll let you know what to do. So, and just explain it to you. Okay, so defense is objected. Your response, Mr. Jenkins.
Your Honor, if there is hearsay there, I'm not trying to elicit that, so I'll try to rephrase the question.
Oh, yes, sir.
Withdraw the question.
Ms. Kovac, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified schedule.
Okay, understood. So you started working with him in a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So originally the schedule, he would come to school at 9:20, get off the bus, and our counselor, Mr. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45 and for like 15-20 minutes do reading with me, and then Mr. Rawls would take him into Ms. Warner's classroom, and then he would leave around, I think, like 10:40, 10:45, get his lunch and then go home.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023. Did there come a time when you were in the office that day with Abigail Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Okay. Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because 2 girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for the potential use of an exception, Judge?
Okay, give you a leeway, yes, sir.
You've indicated, I believe, that 2 girls spoke to you. We'll hold off on what they told you. Can you describe those girls' demeanor or behavior at the time they're reporting it to you?
Yes, I was walking past the room and the 2 little girls had come out to me and said that JT...
Oh, wait, hold on. Before you tell us what they said, what I want to know is how they appeared to you.
They seemed to be scared and worried.
Okay, what did you see in them, what in their bodies or their faces that made you think that?
The actions of them coming close to me, wanting to get my full attention and to let me know, and their faces were kind of like expressive to show worry and concern.
Okay, and eventually they do tell you something, again, without going into what they said. Do they relate to you about something that has just happened, that they've just seen in the minutes before? This is to establish a foundation to use a hearsay exception, Judge. It's
okay, so
foundational.
Hold off on answering. Let me hear the full question, then I can decide on the objection.
Yes, the question is whether the report she receives is quick in time to when she received it. In other words, whether they are reporting something that happened within the last minute, because that's a foundational question for the excited utterance exception.
Mr. T.
Yeah, I think that's clearly leading. He's asking for, she has not even testified anything about what they said or how, she testified that they seemed scared or whatever, but he's getting her to answer by asking her, did they tell you something that had just happened right before you came in contact with them? I mean, that's his testifying.
Oh my goodness.
Okay, well, let me pull out the excited utterance.
Rule 2803-2.
He's asking a foundational question to support the excited utterance exception to the hearsay objection. And defense is saying he's leading and testifying in the form of a question by asking, did what they tell you happen in a time period immediately adjacent to the occurrence they're recounting, which would make it an excited utterance. This, you can't make this stuff up. When all you have is a hammer, every problem looks like a nail, and the hearsay hammer has been wielded all around the courtroom today. Can you imagine if we didn't get to hear these little, if we were up at sidebar every time somebody raised their hand to make an objection, and we didn't realize that there was just basic lawyering 101 issues that were being discussed here. Oh, leading and hearsay. We should document all the different objections that are made, like which ones are made. We've got leading, that he's testifying.
Rule 2803 of the Rules of the Supreme Court of Virginia reads, excited utterance, a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. All right, Mr. Jenkins, I'm going to have to sustain the objection because she's not the declarant according to the rules. The declarant would be purportedly that child.
No!
Judge, could we address this matter outside the presence of the jury, please?
We can. You want to meet me in the jury room or sidebar, or how would you like to address it?
If we can address it on the record, it doesn't matter to me.
Okay, so members of the jury, sometimes you get more steps in than you wish. I'm going to ask you to retire to the jury room, please, and I'll take up this objection.
This is absurd. The judge's understanding of that rule is...
I'd ask that she go into the witness room.
Okay, and one moment, Ms. Kovac, we'll wait for the bailiff to come. I'm not sure that door shouldn't be locked, but we'll wait.
Oh,
Okay, so members of the galley, you can have a seat. Okay, Sheriff, we're going to have Ms. Kovac step back into the witness room.
The judge says, no, we're not going to allow this exception to hearsay because you are not the declarant. You can't tell us what someone else told you because you are not them. What?
Okay, yes, sir.
Judge, I'm sorry. Were you recognizing defense counsel or
No,
defense?
you
Okay.
wanted to take this up.
I do.
So the objective, and yes, your response.
I do. There are two things going on here, Judge. The first is that in an effort to keep things moving, I was asking foundational questions about the excited utterance exception, and if counsel prefers, we can do that as a voir dire of the witness outside the presence of the jury, because whether the excited utterance exception applies or not is a matter for the court and not the jury. So perhaps it would have been more appropriate for me to ask the foundational questions outside the presence of the jury. But regardless, in order to establish the foundation for any hearsay exception, I'm going to have to ask leading questions. So that is why it is usually not done in front of the jury, that we do that outside of their presence. As to the excited utterance, and I will request a moment to pull up some cases, but the rule reads, a spontaneous or impulsive statement prompted by a startling event or condition made by a declarant with first-hand knowledge at the time. When the rule says a declarant, It is not referring to the person on the stand because then they would be here, the declarant would be here. The rule is referring to hearsay, that is the person on the stand reporting what they were told, but the declarant in this case is the girls. They are making a statement that is about a startling event or condition made by them, the declarant, at a time when they were still under the circumstances negating deliberation, because, as I was asking when counsel objected, how quickly were they reporting it? Were they reporting something that happened a year ago, or were they reporting something that happened in the last minute? That was the question I was getting at, to determine whether the statements that the girls made to Ms. Kovac were spontaneous. Ms. Kovac is the person in court today, but she's not the declarant for the purposes of the rule. The declarant is the out-of-court statement. And so if I may have a moment to find a case example, I think I will be able to.
Okay, you may, and I understand your argument, there's a distinction between a declarant and the declarant. And I'll give you a moment to find the case, but projecting this forward, how are you going to lay a foundation of how she would know how soon their statement was made?
You don't need to.
To when
it's
they,
the effect on the listener,
or whatever concerned them, to when it was related to Ms. Kovac.
It's the effect.
Do you have a plan to flush
it's
that
not
out?
affect on the listeners.
I think we should flush that out before we bring the jury back in.
Right, so that's what I'm
yes.
asking. So just thinking forward, that will come next. But yes, I'll give you a moment.
Yes.
Okay, just let me know when you're ready. Hold on to pen, let us find this case.
When they say the state carries a high burden,
Sure.
the state carries this high burden of prosecuting this case and securing a conviction using the laws of the land, in this case Virginia, and also carries the high burden of carrying on their shoulders the burden of educating the judge and the defense lawyer on how the law works simultaneously. The prosecutor, you can tell, is well versed in the law. I don't yet know the experience of the other two. But having to explain to the judge what the declarant is and how that's different than the witness, and why this rule is not telling you what the witness can say on the stand. It has to do with whether or not the witness can use hearsay on the stand as evidence to the jury, because the declarant is the person who told the witness something. It's not talking about the witness saying something, and that is basic. Okay, this is very basic when it comes to hearsay. I realize the rule is very convoluted. I get messed up on some of the aspects of it a lot. This is a basic principle. Understanding who the declarant is in a hearsay issue. This is so bad. Let me see who the judge is. The judge in this one is Rebecca Robinson. She's been handling this case since May 16th. The case started May 18th. It's the same court where the civil trial took place against Miss Parker. Newport News Circuit Court. So it's the same court. This is Virginia's 7th Judicial Circuit. I'm sure Josh is covering this one. I know they're doing a live feed of this case as well, Courtroom Confidential, without commentary. Just a live broadcast. I don't think this judge did the civil trial. It was also this court. It may have been this judge. Runkle's also covering this one. Oh my goodness, this weekend's going to be epic. application for streaming goat has been approved. Oh, this is gonna be good. And we need Rob. Rob is from Virginia. He went to law school. Kurt, oh my goodness. This is the criminal trial of the assistant principal for her 8 charges of neglect for her failure to protect students in this case, because she was given information that should have, according to the prosecution, should have caused her to call the police or lock down the school or do something, because she was given information this student might have a gun. She instead did nothing, denied the opportunity for a teacher to search the person, the student himself. And shortly thereafter, the student did draw the gun in the classroom, shot and fired, hit the teacher, and then was restrained. And the mom has been charged and is doing time for failure to secure the gun, and the charge that went along with it. There's been a civil case where the teacher sued the school district for $40 million, 110. That's done already, and now we're doing the criminal case where the vice principal, assistant principal, is being charged for neglect. The principal's not being charged because the principal was never told of the situation. And unfortunately, the prosecutor, in addition to prosecuting this case, is having to educate the judge on what hearsay is. The judge made a ruling about hearsay, an excited utterance, and said, no, I'm going to overrule. This is not an excited utterance exception to hearsay, that these girls ran out and told the teacher, hey, this guy's got a gun. And her eyes are big and trying to get her attention, because the witness was not the declarant. That was the ruling the judge made. No, it's not an exception to hearsay because the witness was not the declarant. It's textbook excited utterance. I mean, she already described the excited eyes and the trying to get my full attention, and the intensity that the children came up to her with. The lawyer was told to lay more foundation for the exception, was trying to show the timeliness between the two. That was objected to as testifying and leading.
What's the case? One of them is Hicks v. Commonwealth. What's the side? 60 VA App 237.
60 VA App 237?
Yes.
Could you give me a moment just to look at that if you like?
Sure.
I have to say, I like this prosecutor. He's handling this with kid gloves as he gently explains to the judge how the law works. He doesn't want to irritate her because she could be against him for the whole rest of the case, and you don't want to turn the judge against you. But he's gently.
I do. I'm trying to just read it so I can.
Okay, well, we're going to move on. Go ahead, but we're going to have to do 2 things at the same time. Yes, Mr. Jenkins.
Yes, Your Honor. The case that I would cite for the court is Hicks v. Commonwealth, HICKS. It is 60 Virginia App 237, May 29th of 2012. I cite the case only because it is an example where a witness is on the stand and is allowed under the excited utterance exception to testify that the victim of a shooting said he'd been shot. So the declarant in that case was the victim who had been shot, excitedly declaring something spontaneously, while the witness in court was someone else entirely who just heard the out-of-court statement. That's what we have here. Ms. Kovac has heard, I believe we can do voir dire to ensure, has heard an excited utterance from these 2 children, and they are the declarant that the rule contemplates.
Yes, Your Honor. I agree with Commonwealth that the declarant can be someone other than Ms. Kovac. However, in order for the excited utterance exception to apply, again, we can go to the death or the rule. Excited utterance is spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at a time and under circumstances negating deliberation. Ms. Kovac cannot testify to whether these declarants had first-hand knowledge, whether it was at a time and under circumstances negating deliberation. She has no details about that. She would have, because she's not able to, the girls are not here, she's not able to testify to any of that. So the excited utterance exception would not apply.
So the court will reconsider its previous ruling, which I sustain the objection. I will now overrule the objection and allow Ms. Kovac to answer the Commonwealth's question, and the excited utterance rule does apply.
Thank you.
Anything? What was the other point that we were going to consider?
It was
how we
leading.
Lay,
foundation outside the presence of the jury.
The duration.
I would suggest, Your Honor, that before we bring the jury in, we have Ms. Kovac come back to the stand, and I will volunteer her briefly just to establish the concern about the girls' knowledge of what they were reporting, whether it was spontaneous.
All right, we'll bring her back. Please share.
Okay. Got to give the judge kudos for that. Going back and reversing your decision when shown that you're wrong, it takes a big person to be able to do that. A lot of people would double down and stick with it. But kudos to the judge making the correction.
Okay, if you please return to the witness stand. And you are still under oath. We're going to answer some questions outside of the presence of the jury. You may ask you some questions. You may proceed, Mr. Jenkins.
When we left off, you were telling us about two girls running up to you.
They said that JT had a gun in the bag.
Okay. So, upon saying that JT had a gun in the back, could you describe their demeanor in saying that?
They came up to me. They were kind of, like nervous and worried and wanted help.
Okay. Judge, I think that lays the foundation for her to say what the girls told her under the excited utterance.
All right, hang on. We've got some audio issues.
I don't know.
You don't know? Okay. So as far as you know, as far as you know, someone could have told them that, correct?
I don't know.
Okay. Your Honor, just based on that, I believe that this is, again, that she has no knowledge of any firsthand, of how, if the girls had any firsthand knowledge, how they came to get that knowledge. And so then we run into hearsay, possibly hearsay within hearsay, if the girls heard it from someone else. She doesn't know. And so I believe, Your Honor, that this does not come in.
I don't believe you need to know if what they said was true.
I'm sorry. There's one other thing.
Okay, Mr. Jenkins, yes, sir.
How do you know how long? Well, you don't know. You don't even know whether they saw the gun themselves, correct?
I don't know.
Okay, and you don't know. So there's no way for you to be able to know whether they are talking about a gun that was seen or by someone 5 hours ago, yesterday, correct?
I don't know. They reported and I acted.
That's my question. Your Honor, again, I don't believe it qualifies as a substitute hearsay rule.
The legal standard to be applied at this stage in determining whether an evidence exception applies is preponderance of the evidence. She has told us about the girls' demeanor, that they are agitated in that moment, and they say that JT has a gun. I think that to apply the exception, I think that is sufficient for the court to find that it was that they had firsthand knowledge. They were coming and asking for help in that moment, and that it was spontaneous in that they are physically having a reaction to something clearly that they have just seen. And so on the preponderance standard, I think we've met that burden, and she should be able to testify as to what the girl said.
The evidence is admissible. I will allow it in. I will overrule the objection, and can we call the jury back out?
Yes, Your Honor.
Okay. Chair, if you kindly bring the jury back out, and just go back and you just stay there. Go back.
Yes,
Sorry about
okay,
that.
that's fine.
I keep wanting to call you know that.
People do.
Please stand for the jurors. Looks like 14 years in.
Okay, and Mr. Jenkins, if you maybe back up a question or two, and you may proceed with your direct examination.
When we took the break, we had spoken about the question was, what made you warn Dr. Parker, right? And do you remember answering about what did? Let me ask you that. What made you warn?
Your Honor, I don't object. There's been no testimony. I believe you just said warn Dr. Parker. There's been no testimony of that nature.
I'm sorry. I apologize, Judge. Let me withdraw that. That's correct. I need to rephrase that question. That's correct about that. The question was, at some point later, do you tell Ms. Zwerner to keep an eye on JT? Did you?
Yes.
Okay. And what happened to make you give that warning to Ms. Zwerner?
So the girls had reported to me, had come up to me as I was passing right after they came in to say that he had a gun in the bag. And I went into that room with the children and to him to try and see what he would say, to see if I could help and figure out what was going on, because him and I had a good relationship due to the modified schedule.
Okay. And without telling us what you or he said, did you, at that stage, get any information about a gun out of him?
I told him the rules of school, that we cannot have any guns in school, we cannot have any type of weapon in school, and I asked him if he had a gun in the bag.
Okay.
And then we went on with the lesson. He was acting very weird that day, out of character, balled up. I just sat quietly by him. His bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character. He also was talking about one of his friends at the time.
You're not. Here's the objections to what she testified as far as what JT said.
So sustained damage is kind of a narrative. Can you ask another question?
I can. Thank you, Judge. After you had observed these things with JT, did you talk to Dr. Parker?
Not at that moment.
Okay. What did you do as a result of what you observed?
So what I observed is it was time for them to do their assignment. And so JT asked for some school supplies. So I went up to Ms. Zwerner and I said, he needs these school supplies. And I asked her when recess was, that I would be back when recess was, and I was going to check that bag.
I see. At that point, did you go and speak with Dr. Parker?
Yes, I did. At that point, I left the room right away and went to Dr. Parker's office, and I reported.
Hold on just a minute. What, at the time that you go to Dr. Parker's office, do you know what Ms. Zwerner's class was going to do?
They were going to head to recess.
Okay. And when you went to Dr. Parker's office, what did you tell Dr. Parker?
I'm going to hearsay. I believe it's going to be a statement that's going to be offered for its truth.
Absolutely not. It's being offered for the fact that Dr. Parker was given the warning, not for whether the warning itself is true. It's not being offered to show that there is a gun. It's being offered to show that Dr. Parker was told there was a gun.
Mr. Rogers, anything further?
Again, the truth that there was, I guess what he's saying, there was notice. That's a very important fact issue in the trial. So it's offered for the truth of there was a warning.
Mr. James.
I am offering it for the truth that there was a warning. I mean, absolutely. But I'm not offering it to prove there was a gun. And also, Judge, it's a present sense impression. If the court were to find that it's hearsay, which I certainly would argue that it is not, it's also a present sense impression. It's an excited utterance for that matter. It's not offered to prove the fact that there was a gun. It's offered to prove that she was told there was a gun.
Let's pull up the hearsay rules.
The judge just said, let's pull up the hearsay rules. She's cracking open the law books. Courts can allow it if it's not offered for the truth of the matter. If it's a prior inconsistent statement, prior consistent statement, other exceptions like excited utterance, statement against interest, etc., but these are narrower. Or if the witness is testifying about their own prior statement. It's just...
Judge, if I could direct the court to a particular rule and section.
You may.
2801, subsection C.
What about 801D1? Is that...
Which reads, hearsay is a statement other than one made by the declarant while testifying
yes,
at trial or hearing that is offered to prove the truth of the matter asserted. So this does not meet the definition of hearsay for two reasons. First, we are not offering it to prove the truth of the matter asserted. And second, the declarant is testifying at the trial. The declarant in this case is Ms. Kovac.
Oh, my goodness.
And response from defense.
Your Honor, I'll say this. Hearsay is a statement other than one made by the declarant while testifying at trial. Anything that was said outside of her statement on the stand is a statement other than while testifying at trial. So if she said something to Dr. Parker that's other than while testifying at trial, she can testify as to what she observed, but she cannot testify as to something that she said to somebody else.
Made by someone other than the declarant.
So the court's ruling is that it is admissible. There is an exception to hearsay, not only under Rule 2:801, but under Rule, because hearsay within hearsay is what the children told her that she then relays to somebody else. So under 2:805, hearsay within hearsay, it's not excluded if each part of the statement can come in under another exception. So the children's statement comes in under the excited utterance, so therefore it can come in as hearsay within hearsay. So I will overrule the objection, which means to the jury you can consider the response. Repeat your question, Mr. James.
Very simply, what did you say to Dr. Parker?
I went to Dr. Parker and I told her that two girls came to me and said that JT had a gun in the bag, and I told her that's what I told her, that I was warned that he had a gun in the bag. I told her what I did in the classroom, that I sat in the classroom with him, that he was acting very weird that day, out of character.
Okay, and so you relayed that information to her. Ultimately, was there a discussion about any additional action that would take place related to the bag?
I told her that when they go to recess, that I was going to go back and check the bag.
Okay, did Dr. Parker respond to that?
She had just acknowledged it with like a nod.
Okay. All right. So, what did you go check the bag?
At that point, I left. We were doing makeup state testing, so I went to my office, which is past Ms. Zwerner's room. And Ms. Zwerner had texted me at that point.
Okay, I'm gonna have you hold off right there.
Okay.
So just jump with
So
me.
I went.
Okay. Did you at some point go to the room?
Yes.
Okay. And
yes.
what did you do?
When they were at recess, I went back to the room. I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay. And what happened next?
After I checked the bag, I went back to Dr. Parker's office to let her know that I checked that bag. I told her the same items that were in the bag that I had seen.
Okay. And what did you do next?
After that, I went back and I went back outside to Abby and the class that was outside at recess.
Okay, I'm going to pause you right there. While you're outside at recess, without saying what anyone said, were there discussions among the teachers?
There was only her outside with her class at that time, and then I came outside at that time.
Did you and Abby talk?
Yes.
And had you and Ms. Zwerner, again, without saying what the content was, had you and Ms. Zwerner also communicated by text message?
Yes.
Okay. Now, as a result of those communications, again, it doesn't matter what was said, what did you do next?
So, from the result of the text, I then went and checked the bag. I then went and reported a second time to Dr. Parker. Then I went outside to speak to Abby to see if he would come to me because of what she had said in the text. So he was behind the rock wall, did not come to me. And then I told her again.
But wait, you told who?
I told Abby.
Okay. Are there two conversations with Dr. Parker?
There were two times I reported, and then one time I was in the office, and then Dr. Parker had told me that I could tell Abby an action to do if he misbehaved.
Okay. What prompted the first time you talked to Dr. Parker briefly?
The report of the gun.
From the girls?
Correct.
Okay. Briefly, what prompted the second time you talked to Dr. Parker?
The message that I received.
Understood. In the second conversation with Dr. Parker, what did you advise her of?
I advised her that the weapon in discussion was now in his jacket pocket.
And that was your belief?
That was my belief.
Okay. You mentioned that you had been at recess. At recess, did you have an opportunity to see JT?
I did not.
Okay. According to your understanding at the time, what was the protocol for teachers or faculty members to follow when they believed there was some sort of crisis developing?
According to the Richneck Handbook, we were to report to our administrators.
Your Honor, I'm going to object. Hearsay, talking about something in the handbook, it's being offered for it's true.
Response.
Your Honor, I just asked if she knew it, and it is knowledge that she had. She's not reading from anything. She doesn't have the handbook. So she's just saying that she has that knowledge of the policy.
I will allow Aaron to overrule.
Ms. Kovac, I want to take you to the moment on January 6th that a gunshot has happened. Do you recall that moment?
Yes.
Okay. And what was your first thought and what did you do?
My first thought was, he had that gun, he shot it, and I walked in that room. He hated me.
By in that room?
In Abby's room, room 11.
Okay.
He hated me.
Okay, hold on. Let me walk you through it. When you walk into the room, what do you see?
I walk into the room, Abby is to my left, and I see blood on her leg. So I know she was hit. To my right, the children are running out and screaming, going across to the hall to the open door. And he was standing right in front of me, arms crossed, legs spread, and cocky.
Okay. At that stage, do you see a gun anywhere?
I do. It's on the left, my left, slightly under the reading table.
Okay.
I went straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder. Watched enough shows. I took him to the front of the room. I sat in Abby's chair. I put him in between my legs and my arms, and I picked up and I called 911.
Okay. And then after you did that, do police eventually arrive?
Eventually. It felt like eternity.
Yeah. So when they arrive, what position are you in? Are you still that same?
I'm still in that same position. So we were facing, like the phone is here, and we were facing as the police were coming in.
Okay. And as the police are coming in to the room, what is going on with JT? What is he doing?
I'm going to object to relevance at this point.
Relevance?
It's not relevant to these proceedings at this point. What happened after the gunshot, or whether Dr. Parker is guilty of anything. We've gone beyond what's relevant here.
Okay, I can see a little bit of that argument.
Your Honor, the statute contemplates the event. I'm sorry, there couldn't be anything more relevant. The event of the shooting and its immediate aftermath is precisely what Dr. Parker is charged with. The effect of her omission is what we're hearing right now. And so this is the very circumstance. It is the immediate shooting and its aftermath, and its after effects for these children. And what she's describing is a present sense impression of something that is occurring as it's occurring.
So I will overrule the objection in terms of it's part of the incident and the immediate aftermath. Now the ongoing effects, there are going to be some limits on that. We can't talk about, I don't expect to talk about things more than 2 hours after this incident. Are you going past that?
Not with this witness, Judge, but with children and families that experienced ongoing effects from the neglect, but not with this witness.
And we'll take that up at a later point. But yes, you may continue with this witness and objection overruled.
When police arrive, that's the part we're talking about. What is JT doing?
He is in my arms, and they asked me if I was okay, and if he was okay, and we were both okay. He became more agitated and cussing up a storm, and eventually, he was just spewing cuss words, stating, that he.
Your Honor, I'm going to again object to relevance here, and also the fact that his testimony is really more prejudicial than probative of any element of the offense.
Any response?
I think the court has already ruled on that.
We didn't talk about prejudicial versus probative. You want to respond to that portion of the objection? That's a new objection.
Sure. All of the Commonwealth's evidence is prejudicial by definition. The question is whether it is probative. Probative is another word for relevant. Dr. Parker is charged with neglect of children that caused a shooting, and the testimony is about the shooting and its immediate after effects while there is still a gun on the floor, while police are arriving. So it is relevant, it is probative, highly probative, and therefore admissible.
So to the two-part objection from the defense, the court overrules it. The first part I previously ruled, so I note your continuing objection. As to the second part, prejudicial versus probative, it has to be, I think, substantially outweighed according to the admissibility standards in this case. Therefore, I rule it. I'm going to allow the testimony. You may consider it. Do you need him to repeat the question?
No.
Okay, you may finish your answer.
Okay, he was in my arms, he was getting agitated, he was cussing. I told him Mrs. Kovac does not like that language. He turned, gave me the finger, and then when I turned my head back, he punched me. My glasses went off, and I said that I was done, and I turned him over to the police.
Okay, and at that point, did you leave the room?
At that point, I did leave the room.
Okay, thank you. Now, Ms. Kovac, if you know, were police wearing body cameras while they were in there that day?
I knew that the one police officer said that he had the body cam on and got the whole transaction and my assault on the body cam.
If I were to show you a still picture from that, would you be able to recognize yourself and JT?
Yes.
Judge, I'm going to ask permission to show that to the witness at this time.
Okay.
And are you approaching the witness stand, or are you going to just lay it on the television?
First, I'm going to show it to defense counsel, then approach the witness stand until I've laid a foundation to show it.
Oh, yes, sir. Thank you.
May I approach the witness, Judge?
You may.
I'm just going to ask you to take a look at that. Can you see it clearly?
Yes.
I'm going to return and ask you some questions.
Okay.
Ms. Kovac, having had a chance to look at that still frame, does it depict you in the exact setting and circumstances that you've just testified to?
Yes.
Does it appear to you to be a fair and accurate representation as a still of a moment of that interaction you've just described?
Yes.
All right. Judge, I am going to move to admit this into evidence as Commonwealth's 1. It is a video that is approximately 2 minutes and 51 seconds. It depicts the things about which she has testified.
Your Honor, she was not showing video. She was showing effectively a picture that showed her sitting with this child in her arms. There's no way, based on that, just seeing a picture, that she can properly authenticate that video. So what we need to do is exclude the jury, let her see the video, and then she can testify that she's
seriously
what that video portrays accurately describes what occurred on the day. But right now, just based on a picture, that doesn't authenticate. Well, effectively, it's a picture, doesn't authenticate the video.
Your Honor, additionally, Your Honor, I believe the video is cumulative, and again, it's just shown to prejudice Dr. Parker. It's the prejudicial value substantially outweighs any probative value that a video of the interaction would have.
I'll address the first one. It sounds like it's an authentication objection. I was hoping we would avoid sending the jury out, but counsel is right. If we, to authenticate the video, I need to show her the video, and let her authenticate it. So.
Okay, yes, because you said it's still photographed.
That's right.
Now we're talking about 2 minutes and 51 seconds. But I mean, if you could just play it without the volume, if that's adequate, I don't know, then she can just watch it right there in the witness stand.
For her,
before we publish it.
Yes, without the audio for her purposes.
Yes, if that's sufficient for authentication. And again, I don't know, I haven't seen it.
That's sufficient for me.
Okay.
I don't know.
And then what was the second objection, prejudicial versus probative?
And cumulative, Your Honor.
Cumulative.
And say, I didn't hear you.
Cumulative.
Cumulative. Okay. So I overrule on both of those. And Mr. Jenkins, are you able to play it?
Yes, Your Honor.
And so again, he's going to approach and play it pretty silently. Yes, ma'am.
We're still having trouble hearing.
Still having trouble hearing them. Okay. Mr. Rogers, I don't have a microphone. I don't know what we can do if they still can't hear you.
Yes, ma'am.
Nobody ever has trouble hearing me.
It's because you speak into a microphone.
We're just going to sit quietly while this.
She's now going to watch a 2 minute and 51 second video without any audio, because defense said there's no way you can authenticate the video from a still frame. You have to actually watch it move to know that this is what happened.
And while she's watching that,
why
should she be able to state that it's a fair and accurate representation? Are you going to put it on the big TV?
That is the point.
Is the podium turned on? It takes about 2 minutes to warm up.
It is on. I tested it earlier.
I was going to say, get it started if it's not started.
It looks like someone has changed the TV since I tested it earlier, though.
Okay, so let's find the right source. Input.
Okay, great.
the prejudicial over probative.
That's it.
We're good. Your Honor,
This is
could I just add to our objection to the video? Your Honor,
another objection.
our finding is that we started with 8 counts of abuse and neglect of children. What happened to Zwerner is tragic. And the behavior that Ms. Kovac had to endure on that morning after this shooting event, that was tragic also. But I believe she testified that the shot was fired. She turned around and went into the room, and as she was going into the room, the children were leaving the room.
What's your objection?
There were no children present. They weren't at the moment that she's about to testify, there were no children that were subject to abuse and neglect.
Okay, this sounds like a motion to strike, so I'll hear that then. Okay.
So that's number 25. Motion to strike because there were no children in the room at the time that she's testifying of, which was after the shooting. But this is immediately after the shooting, which shows the scene. But the charges they're not charging for neglect for the way the teachers were treated, either getting shot or getting punched by JT. They're only charging for the neglect of the children. The child's present at the time. It counts. And the 6-year-old, the shooter, was a child who they also had the same responsibility to. Shelley, okay, I see your comment. Let's see if there's another one. Our necks are tired. You had a rough one previously. Is this?
Okay, may I approach, Your Honor?
You may.
You need the comic relief that we're getting from this one. Is that it? Is there another comment I missed?
Ms. Kovac, you've just watched a video. I'm sorry, is that yes?
Yes, sorry.
Thank you. Does that video fairly and accurately show what happened in those moments that you were just describing in your testimony?
Yes, it does.
Judge, I do move the video into evidence as Commonwealth 1.
Defense, we already objected, so there's some noted, no parole, and you may play the video. This will be marked, again, you said Commonwealth 1?
Commonwealth 1, Your Honor. And for the purposes of
there it is. Found it.
media coverage, this video, we have muted the name of JT and
everything else. So the video is going to be blurred. Okay, Shelley, and okay, I'm a bailiff. We have a jury back deliberating. The clerk, judge, and I are watching flabbergasted. Judge thinks the prosecutor should be the judge here. I'm with the judge on that. Give me a second. We're muted and blurred because this part is ordered not to be shown.
And I believe you...
Hang on 1 second. We need to go back.
Testified that...
Just a second. I fast forwarded too far. That's the end of the state's case there, I think. Just 1 second. Blur, blur, blur. For 2 minutes and 51 seconds. Sorry, got to get it exactly perfect. They take a break or something? Okay, we're just gonna watch the blur because I can't seem to find the exact moment. This might be about 30 seconds to a minute of blur we get here, or less. I'm going to lean towards the less side. Shelley and okay, big shout out to the clerk, the judge, and the bailiff watching this as you wait for your own jury. Welcome. Good to have you here. We had a rough trial, so this is a refreshing change while we wait, although I'm going to have to order the jury lunch I just found out. Well, make it good. Make it tasty. I'm going to say sandwiches today. Let's do sandwiches if we could. I think that would be great. Okay.
a envelope labeled Kovac JT in classroom. May I approach?
You may, and so marked and so received.
So that is the video. It's just been turned over to the judge.
Thank you, Ms. Kovac. I don't have any more questions for you, but please answer any questions from defense counsel.
Your Honor, before I start my cross-examination, can we take a brief recess?
No.
Okay.
Or can I just step out?
Yes, you can step out. We'll just be quiet. Yes, sir.
We'll just be quiet. Okay, that's the part I couldn't see where we were at. Okay. Can I just, Your Honor, could I just leave for a little while? Yell into a pillow maybe? Read the law books? Do something outside the presence of the jury? Quick huddle outside. We're going to skip ahead as they huddle. Let's see. They're still huddling. They took a few minutes. Now we're going to be coming back here in just a second. All right, and now we're coming back. They took a few minutes, more than just a quick second. How come they didn't tell me this in law school? This judge is eating my lunch.
Okay.
Oh, I didn't go to law school. That's right.
Yes, ma'am.
All right, please do.
Okay.
The lectern mic is picking up all the papers, not the voices.
Name is Amy Kovac?
Yes.
And I believe you testified that you have been a reading specialist for 16 years?
13.
13 years? And how long have you actually been a teacher?
33 years.
A lot of experience in the school system.
Correct.
Is that entire time with Newport News City Schools?
No, the first 10 years were in King and Queen County. I've been with Newport News for 23 years.
Okay. All right. And would you agree that you had actually spent a lot of time with JT prior to this incident?
On the modified schedule, yes. So from October through January.
So you were used to his ups and downs, is that correct?
Correct.
Okay. He had good days?
Yes, with me.
Okay. And obviously, even prior to this day, he had some bad days?
Correct.
Would you agree that the Wednesday prior, just immediately prior, he had a bad day?
Correct.
Were you there to see and observe his behavior on Wednesday?
In the classroom?
After the classroom incident?
I was in the office when he was brought up.
Okay. All right. And are you aware who brought him up?
Mr. Rawls.
Okay. All right. Do you know why he was brought up?
He didn't tell me then. I called for the buses at that point.
Okay. But you knew there was an incident in the classroom, that he was brought out of the classroom? Is that correct?
I knew that he was in an incident and was carried to the office.
Okay.
Carried.
Right.
Whoa.
Okay, good. All right. So would you agree that it's the teacher's responsibility, primary responsibility, to make sure that the students in their classrooms are safe and protected from any harm?
It is the teacher's responsibility to teach the children, to have a schedule for the children, and to handle disruptive behavior, not excessive behavior, is my understanding.
Okay. So you would agree that if there's a disruptive student in the classroom, the teacher has the authority to remove that child from the classroom?
She can usually call for help. That's what I would do.
So you're saying no, a teacher cannot remove a student from the classroom for disruptive behavior?
I mean, to another classroom. It just depends on what the classroom plan is and the school's rules are.
So yes or no?
I don't know.
You don't know? Okay. All right. Have you ever removed a student from a classroom for disruptive behavior?
In my classroom as a general ed teacher?
Sure.
Or as a reading specialist?
A general ed teacher?
Yes, I've moved into another classroom.
Okay. All right. You would also agree that a teacher has the ability, if a student is disruptive, to take them down to the administrative office?
If there's someone to watch their class if needed.
All right. So obviously, you don't want to assign any blame or responsibility for the classroom teacher for JT's behavior on that day. Is that correct?
Objection. This calls for speculation. Is an opinion about whether she wants to assign something to someone.
I'll let the court rule on it.
This cross-examination is allowed to fully vet the witnesses.
It's not my place. I mean, I don't know it. I can't think for somebody else. I can only think for myself.
Okay. All right. So let's start when you first became aware that there may be a problem with JT. Okay. I believe it was the incident with the two young girls. Is that correct?
For that day?
For that day.
No, that was not the first time.
Okay. What was the first time that you had any kind of indication that JT was having a bad day?
When Ms. Zwerner came in to report that he had been acting up in the lunchroom, and she was reporting to Ms. Parker, myself and Ms. Harris were in there because it was testing, and we had just returned our tickets. Dr. Parker did not look up at her, did not acknowledge her.
Okay. You did not observe this behavior yourself. This was just something.
I did observe that behavior.
What observed?
Not just his behavior.
That's what I'm talking about. I'm talking about JT's.
But Dr. Parker and Adam's behavior.
JT. You just accidentally said a name.
All right. And then you had the encounter with the two young girls. Is that correct?
Correct.
All right. And so it sounds like, based on your testimony during direct examination, that that you believe the girl's assertion that JT had a gun. Is that correct?
Correct.
Okay. So obviously, if JT had a gun, then he presented a danger to the students in his classroom. Is that correct?
Correct. Correct.
Okay. All right. So you went to investigate that. Is that correct?
I walked into that classroom to speak with him.
With the belief that he had a gun. Is that correct?
With the belief that there was a possible weapon.
Okay. All right. And so, and you observed that he was acting off. Is that correct?
Correct.
Okay. You, along with his teacher, had the authority to remove him from the classroom. Isn't that correct?
We had already told her that the...
I'm talking about your authority. You had the authority, along with Miss Zwerner, to...
I don't know.
Okay. All right. But even with you indicating that you believe that he had a gun, you spent some time with him, and then you left him in the classroom, even though you believe that he had possessed a gun. Is that correct?
I left the classroom to report as required by my school.
If a student had a gun, don't you believe it's required that you separate that student from the other students so he doesn't present a danger of harm to those students?
Objections been asked and answered 3 times now.
Response.
Your Honor, I'm just trying to make sure that she clearly indicates what her responsibilities are regarding the safety of the children.
Ask us one last time.
For the safety of the children, I did not remove him at that point.
All right. So then you said that you actually spent some time on the playground when JT was with his classmates. Is that correct?
I went out to the playground, did not spend time. I was testing and had to get back.
But you believe that he had a gun on the playground. Isn't that correct?
I'm not sure what kind of gun, I'm not sure what kind of weapon. I had not seen it myself. I only heard the reports and I reported as required.
But you said you believed it was a gun. Is that correct?
Because the girls reported.
And you believed them?
Any report of a weapon in a school, I'm reporting. And I did it.
All right. Is there
More than once.
Is there a possibility that you thought it was a toy gun versus a real gun?
My personal thoughts are my personal thoughts, so.
Did you express to anybody that you thought it was probably a toy and not a real gun?
Yes, after the incident, the police have it on police cam.
Right.
That was my thoughts while I was in shock.
Okay. So you believe there was a real gun, and then you left the other student?
I did not know if it was a real gun or not at that point when I was in the room with him.
So you didn't believe that he had a gun?
Objection, Your Honor. He is misstating her testimony over and over within his questions.
Response, Mr. Rogers.
Your Honor, she's trying to have it both ways. She indicated on direct examination that she believed he had a gun. Now that I am assigning her responsibility to her, she's trying to say that, well, I don't know. What I believed at the time, she's acknowledged that she did tell somebody that there was a toy gun. So I'm just trying to narrow down whether or not she believed it was a gun or not.
Okay, and your objection to fleshing that out is what, Mr. Jenkins?
It's that she has already said the answer. She has already said that it could have been any kind of gun she didn't know. And he keeps restating her testimony differently than that. He keeps saying, you believed it was a gun. And she keeps saying, I didn't know if it was a gun.
Well, I think he switched to her saying something different purportedly on the body cam that now it's a toy gun. And again, strong cross-examination, vigorous cross-examination is fundamental of our justice system. So overruled, you may proceed, Mr. Rogers.
Your Honor, may I address one other issue?
Yes.
I'm hearing in the courtroom gallery commentary for coming over my right shoulder. I just think the gallery needs to be informed that they're not.
Okay, and I can do that. And I heard something, I just couldn't tell the direction. I need absolute silence from participants in the courtroom. We cannot comment, we cannot bolster, we cannot suggest our opinions in any way. Please govern yourselves accordingly. This is an open public proceeding, but if people are disruptive, they will be asked to leave. Comments are considered disruptive, and I can't close this courtroom. I'll ask everyone to govern themselves accordingly, and I think the sheriff will start keeping an eye out for that. I know he was. So Sheriff, if anybody's making noise, please escort them out. Thank you. All right, please proceed, Mr. Rogers.
Thank you, Your Honor. So it sounds like now you're saying that you weren't sure if he possessed a firearm. Is that correct?
What I'm saying is the girls reported that there was a gun.
And you believe them?
And I...
Yeah, let her finish her response, Mr. Rogers.
I acted on the report. Children were 6 years old, first grade. I acted on the report. I went to see what was going on with him. I did not look in the bag. I did not touch the bag. I was in the room. When I left the room, I went and reported to my administrator.
Did you leave that?
Are you finished your response? Yeah. Okay, next question.
Did you leave that room believing that there was a gun?
I left that room believing that there was something in that bag.
Something that potentially presented a threat of harm to those children.
This is ask and answer, Mr. Rogers.
All right.
Next question.
All right. All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground. Is that correct?
Correct.
All right. You said that you didn't visually see him yourself, but you knew he was present. Is that correct?
Correct.
Okay. He was out there with his classmates. Is that correct?
Correct.
All right. Miss Zwerner, his teacher, was out there. Isn't that correct?
Correct.
Okay. There was nothing that prevented you or Miss Zwerner on that playground to separate JT from the rest of his classmates. Isn't that correct?
No.
All right. So you said that you searched his backpack. Is that correct?
Correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No.
Okay. So you continued to think that he potentially had a firearm. Is that correct?
Something. He had some kind of weapon.
When you say some kind of weapon, are we talking? Are you
talking gun? Because that's what the girls reported. I did not know what was in that bag.
So are you holding out the possibility that it's a toy gun?
I'm not sure what it was.
Yes or no?
It could have been, yes.
All right. So if it was a toy gun,
we still report and we still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children. Isn't that correct?
If there is a report, it is required by the state that you report.
Do you understand my question?
I do understand your question.
Okay,
hold on. For everybody, we're going to lower the temperature in the room. So the objection would be non-responsive because she did not answer your question. She answered a different question. Can you repeat your last question, Mr. Rogers?
Do you believe that a toy gun presents a threat of harm to those students?
He couldn't. Yes. Yes, it could.
Okay, explain. How in the world a toy gun could present
a BB gun, a water gun,
I said,
any kind.
My question was...
She answered the question. What's the next question?
Okay. So you consider a BB gun as a toy gun. Is that correct?
It's a gun. You report for any type of weapon. I reported it.
All right.
Schools have zero tolerance for weapons, so yes, everything gets reported, even if it's just toy, complete toy, not capable of firing anything.
Just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
All right. Do you think it may have been important to take them down to the office too?
I did the actions that I did in that day, and I cannot look in retrospect.
Okay. Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to. We just cannot check your body without permission from the administrator.
Okay. So did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay. So let's talk about, you said you're a part of the crisis, what is it, crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan. The district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and if the principal and administration gives me another duty, then I do that.
Okay. But nobody told you Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom. Is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
Okay. At what point did the students leave the classroom?
When I was walking in, they were coming out.
Okay. So by the time that you took a hold of JT and sat down with him, there were no students in the classroom.
There were students in there.
Can I have a moment?
Okay.
Fence huddle going on.
After the firing of the firearm by JT, one of the steps that you took was to call the police. Is that correct?
Once I had a hold of it, yes.
Okay. So that phone was readily available to contact the police?
It was her school office, it was her school phone.
Okay. Were there also walkie-talkies that could be used to communicate with administration?
There is, but I did not have my phone or my walkie because testing had just finished. And state testing, we cannot have that. So I had none of those.
But you did have the classroom phone that you could have easily called down to the administrative office, isn't that correct?
After the shooting I did call, I was busy the whole time.
All right. So before then, you took no steps to call the police, is that correct?
Correct.
And okay, so, but you did communicate with administration face-to-face, is that correct?
Correct.
All right.
Several times.
All right. After the incident, did you have communications with Dr. Parker?
Yes.
Okay. You understood that she was very upset about the things that occurred on that day, is that correct?
Well, first of all, I was in shock that day. I did speak to her. We were considered work friends, so I checked in on her. I asked her if she called her husband. I asked her if I could use her phone to call my husband.
Okay. And you indicated to her that the events that had occurred on that day were unfortunate.
Objection, hearsay.
Okay, so go ahead, finish your entire question, and then I'll move on to the objection.
You indicated to her by some communications, by text or in person, that you believe that the events that occurred on that day were not foreseeable. Is that correct?
Okay, and hold on, that's where I'm going to go. Okay, and your objection is what? You fleshed out a little bit more, Mr. Chamberlain.
So he's asking about an out-of-court statement offered for the truth of the matter. He's asking about an out-of-court statement that she said to Dr. Parker. So it's yours.
Response.
I'll submit it to the court.
Okay, so suspect. All right. So do not answer. Next question again.
He's drumming his fingers.
Okay.
On the
and so, just briefly going back to the backpack. So, you searched it, didn't find anything that you believe presented a danger. Is that correct?
Not at the time, correct. Yep.
Okay. Did you observe at all JT on the playground? Did you observe what he was wearing? You know, anything that he may have had in his pockets?
No.
All right. All right. I'm going to check with my co-counsel one more time, and then I don't think I'm done.
Yes, sir.
we're ready for lunch. What do you think?
I'm sorry, I just want to return to the backpack again. When you asked JT to search, to let you look into his backpack, and he said no, was that alarming to you?
His actions were alarming to me.
Okay.
Words that come out of his mouth, it's hot and cold every day.
So you're saying you didn't take that seriously?
I took it seriously because I reported 3 times to the administrator.
Okay, but not seriously enough to say, let's take JT to the office, or let's get his classmates out of this classroom, because I think that...
Objection asked and answered.
Talking about the backpack now, Your Honor.
I'll allow it. Go ahead.
All right. So not enough to take JT's classmates out of that room for any potential harm.
I did not know what his next actions would have been at that moment, and to keep the children safe if there was something, because a weapon had been reported and no administrator did actions.
Okay, so you could have taken some steps to keep them safe.
I did, as what I could at that time.
Okay, so that's all you could have done is reported to the administration. You couldn't have taken JT out of the classroom. You couldn't have taken the students out of the classroom.
In retrospect, maybe, but I did what I did.
All right. That's all the questions I have.
Can you redirect?
No, Your Honor. Thank you, Ms. Kovac.
And this what the status in terms of being sequestered, excused?
I would request the same with all of our witnesses. I'm asking that she remain sequestered but be able to leave. Certainly she is subject to recall by either party.
I agree.
Okay, so Ms. Kovac, you are welcome to leave the building, but you are still a sequestered witness, meaning you cannot discuss this case until the trial is over. And it's my understanding that attorneys have your number, so if they need to call you back for subsequent testimony, please be available. All right, thank you, ma'am. You may step down. Again, you're welcome to leave or stay, but you can't stay in the courtroom. Okay, we do another witness. Got about 20 minutes before we break for lunch. Can we start with another witness?
Judge, I have one witness that we could do, I think, very quickly.
Okay, who would you like to call, please?
Deputy Blythe.
Blythe?
Blythe, B-L-Y-T-H.
Okay, thank you.
Like from Anne of Green Gables, Blythe?
Sheriff, Deputy Blythe, please. Thank you.
This is Gilbert.
All right, good morning, sir. Please stand in front of the clerk and get sworn in.
Do you swear affirm the testimony you're about to give us the truth, whole truth, and nothing but the truth?
I do.
All right, please take the witness stand. Watch your step, and you may adjust the chair and microphone.
Good afternoon, sir. Please tell us your name.
My name is Thomas Blythe. I'm a retired deputy from the Newport News Sheriff's Office.
And were you working as a deputy on January 6, 2023?
I was.
And on that day, did you have occasion to go to Rich Neck Elementary School in Newport News?
I did. I responded to a radio call of an active shooter at the school.
All right. And did you go to the school?
Yes.
And what did you do when you arrived?
Pulled up in front of the school. Deputy Briggs about a half second behind me. We went to the door, tried to get in, but the intercom wouldn't work at the door. There was nobody to meet us. Everything was locked up. We were joined by a couple of Newport News police officers. All four of us pounding on the windows, yelling, trying to get somebody to open the door for us.
Okay.
School's on lockdown.
Did you observe an intercom system of sorts on the door on the outside?
There was an intercom on the door. It didn't appear to be working, or at least nobody was answering it.
Okay. Eventually, does someone let you in the door?
After about a minute, it was either, I think it was a janitorial staff.
Okay.
Opened the door for us.
And roughly how long were you out there prior to a janitorial staff opening the door?
I think by body camera it was about a minute, maybe a minute and a half.
Okay.
Felt like an eternity.
Yeah. Were you armed and willing to go in and confront?
We were in full uniform, armed, responding to what we thought was an active shooter.
All right, thank you. I don't have any further questions for you. Please answer any from defense counsel.
That was a quick witness.
No questions.
Very quick.
Does Detective Blythe need to remain?
No, I actually, if there's no objection, I think he could be released. Yes, so we would like to release him from recall.
Okay, to confirm defense position.
No objection to him being released.
Okay, so thank you, Detective, for your testimony. And being released means you are welcome to stay in the courtroom or you may leave. Thank you, sir.
Thank you, Your Honor.
All right, next witness.
Judge, my remaining witnesses may take a bit more time than that one. Do you want to go?
I would like to start. Yes, please.
Now I'll call Brianna Foster, please.
Brianna Foster. Ms. Foster, please.
Okay, here's the principal. This is the defendant's boss.
Good afternoon. Please stand in front of me to be sworn in.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, and you may adjust my phone to me. Any questions the attorney may have.
Good afternoon.
Good afternoon.
Would you please tell us your name?
Brianna Foster.
And Ms. Foster, back in January of 2023, how were you employed? Okay, I'm going to ask you to speak up a little bit. It can be kind of hard to hear. Did you say that you were could you repeat what you said?
I was employed with Newport News Public Schools as a principal.
Okay, and what school were you a principal at?
Richmond Elementary.
Okay.
Why are we not showing her?
Ms. Foster, if you know, had your school at Richneck Elementary adopted a crisis and emergency management plan?
Yes.
And if I were to show you the plan, would you recognize it?
Yes.
Okay, Judge, may I approach?
You may.
Yes, yes.
Looks like they might object here.
May I approach?
You may.
The lectern, by the way, is for folding origami, as both lawyers have demonstrated.
Document there, and I'll ask you some questions about it. You don't have to say anything about it.
You can use the microphone to form the creases.
Kind of getting ahead of this, if they're going to try to say anything out of that document, it's going to be offered for the truth of the matter asserted, and I'm going to be objecting to that document as hearsay.
All right. Understood that that's coming, and when it becomes right,
So he
I'm
just
ready to hear the objection.
put an objection on the record prematurely.
Ms. Foster, just let me know when you've had enough time to look at that document.
It's hearsay, by the way. Anything in that document is hearsay. Yeah, what about business records? What about a business document? A record kept in the course of regular business. Might be ways around this.
My question is going to be, is that a fair and accurate copy of the Rich Neck Crisis Management Plan as you remember it?
I cannot answer that in full, but I remember that it's a fair and accurate representation.
Understood. I'll take it back. At the time that you were working on January 6th of 2023, were you aware of the crisis management plan?
Yes, I do recall that we have one.
Okay. And what was the purpose of having a crisis management plan at all?
We're just required to, every school is required to have one.
Okay. Was it your intention that you would follow the crisis management plan in a crisis?
Yes.
Okay. I want to take your attention then to January 6, 2023. On that day, was there a crisis incident that occurred at the school?
Yes.
Okay. And what was that in brief?
Later that afternoon, I found out that there was a student, it was reported that a student had a weapon.
Okay. At any point, was there a critical incident that required police to show up?
Would you mind clarifying what you mean, how?
Did something huge happen on January 6th of 2023? That's the whole reason we're here? Okay.
Was there a
and
big
what was
bad
that?
thing?
That a student shot his teacher.
Yes. So I want to ask you, prior to that moment, the moment of the shooting, had anyone...
Your Honor, I'm sorry. I'm going to object to her response to the question unless she actually observed the incident. I don't think that she was present when that occurred. So she can testify to what she observed, but she has made a conclusion that I don't think she can really
She can't conclude that a bad thing happened at her school that day.
Judge, it's the incident for which we are here. She's the principal of the school. She knows what happened at the school that day. I'm just trying to orient her in time so that I can ask a question.
So I'll overrule it as receiving that posture as to why are you here in court today, the incident that brings you in court today. Not that she observed it or anything further than that without further questions and testimony.
Thank you,
So what's your next question?
Prior to that event occurring at your school, did anyone tell you that JT or anyone that there was a weapon on campus?
Yeah.
any hint from anyone that there was a weapon on your campus prior to that? Roughly how many students attended Rich Neck at that time? And I don't mean on that day, but just the total number of students that would have been in the school. And you can give us an estimate.
I truly do not recall, but if I had to give you a number, maybe 500.
Okay.
500 maybe?
I want to talk to you about a student named JT. Are you familiar with who I'm talking about?
Yes.
Okay. We're not using any student names at all, so any students that you mention, please don't use their name. Had you personally, prior to the incident on January 6th, so earlier that year, had you personally had any issues with JT's behavior that you saw?
Yes.
Okay, what's the objection? I didn't hear you, Mr.
No, that's right.
Well, okay, response?
If she handled a discipline issue with JT that the defendant knows about, then it's relevant, as all of those are.
We've allowed those in previously, so I'll allow this in to be consistent. So you may proceed. You can answer the question. Do you need him to repeat the question? Yes, please.
So the question was, in the time before, the days before the shooting, had you personally been aware or observed behavior of JT that was a discipline issue?
Yes.
And could you just describe that?
To my memory, earlier that week, there was a situation that took place between him and his first grade teacher involving her cell phone.
Okay, and did that situation come to you?
Yes.
And who appeared to you to inform you?
I think it was 2 people that came to me. I don't remember if it was his teacher.
Okay.
I'm sitting here trying to think back exactly how I knew about it, but I remember calling his mother that evening.
Okay. So as a result of that incident, you did contact his mother?
Yes.
Okay. Any other specific instances, discipline-wise, of JT that year? That you remember? If you don't remember, that's fine to say that.
Not in detail, but there were other incidences that took place.
Okay. If you know, did the school attempt to do anything to try to moderate that behavior?
Yes.
And what was it that the school did to attempt to control the behavior?
I don't remember the name of the process that was in place. However, they met, it was a scheduled number of, let's say, weeks or throughout the month, where they would meet with the teacher, assistant principal, parent, and Ms. Kovac to go over his progress, academics, behaviors, and come up with a plan, essentially progress monitoring how he was doing it in school.
Okay. And I just have one last question for you. Is it true that you were working at the school hand in hand with Dr. Ebony Parker?
Yes.
Okay. And is Dr. Parker in the courtroom right now?
Yes.
Okay. Could you please just describe what she's wearing and identify her for the judge, or point her out?
Yes. She has brown and black hair. If I'm mistaken, she has some blue.
And just may the court recognize she's identified the defendant?
So noted.
Thank you. I have no further questions for you. Please answer any questions of the defense counsel.
Thank you.
Can I take a moment?
Yes.
The world's quietest witness refuses to talk into the mic.
Good afternoon. How are you? Just a few questions. There was a crisis management plan in place. Is that correct?
To my knowledge, yes.
Okay. Okay. All right. I'm sorry. So there was a crisis management plan in place. Is that correct?
To my knowledge, yes.
Okay. And if there were any type of crisis at the school, had you instructed any of the teachers or staff not to come to you with that crisis?
No.
Okay. Was it the policy of your school for staff members to bring problems to Dr. Parker, and if whatever she said goes, or were you ultimately responsible for the safety of the students at your school?
To my knowledge, it's a joint. In my previous positions, it's hard to say. Like, ultimately, I am as a principal, yes.
Okay. So, would you expect your staff members, if they weren't satisfied with whatever was brought to the assistant principal, that they should bring whatever that crisis or problem to you?
Yes.
Okay. Did that occur on January 6th of 2023?
No.
So you have to double report? The assistant principal has no responsibility to pass it up the chain?
Could any teacher who had a disruptive student in their class, could they have brought that student to the administrative office?
Yes.
Okay. Would you expect them to bring that student to the administrative office?
Yes.
If any teacher or staff member had the belief that there was a firearm possessed by a student, would you agree that that student should be separated from the rest of his classmates?
Yes.
Okay. Would you also agree that law enforcement should be immediately notified?
Yes.
Before the shooting, as far as you know, did any of those steps take place?
To my knowledge, no.
All right. Can I have a moment, Your Honor?
I'm just going to put this out there. You can't take the authority away from teachers and also put the
Your Honor, that's all the
responsibility
question.
on them.
Thank you. Any three correct?
I'm not saying bring back corporal punishment, but you can't tie their hands and hold
so
them accountable.
on January 6th, during that day, what were you doing and where were you in the school?
Do you know the timeline of the whole thing?
As much as you remember, fair enough. If you don't remember, you can say you don't remember, but just as much as you remember, where were you and what were you doing that day?
That day we had some interviews in the morning. I subbed for a giving teacher a break so she could handle lunch for herself, a personal lunchtime.
Now, when you were doing the interviews, where would you have been in the school?
The main office,
in your office, okay. And then the second thing you said you did was what again?
Relieving teachers so she could have a lunch break.
So that would have been in a classroom?
Yes.
Okay. Then what?
Then I remember we had a family and military life meeting with the new partnership that we were forming.
Okay, where did that occur?
In our conference room.
Okay.
And then after that, during that meeting, I remember emailing our lead custodian to ask about, I think I walked through or emailed our lead custodian, maybe Dr. Parker, asking about space, because they wanted to know about space, and I couldn't remember off the top of my head where we could put them. And then after that meeting was over, Dr. Parker and our lead custodian came to my office, in addition to 2 students who were waiting to speak with me, came to my office.
Okay. And while you're in your office, what's the first signal you get that something is wrong?
I think the words I heard were, he has a gun, or she's been shot.
Okay.
And then
what did you do?
From there, I slammed my door, and I took the 2 students who were in my office and everyone else, and I shoved them into the bathroom and tried to barricade them in. I called my direct supervisor and 911, and was telling everyone in the bathroom that I'm going out. And I remember someone saying, "You can't." I have to. And then when I went out, Miss Zwerner was on the ground, and there were staff. And I remember saying, like, "Please put this school on lockdown." And Miss O looked up. I looked up, and Miss O said she had already put the school on lockdown.
All right. Thank you. I don't have anything further for you.
Your Honor, I don't have any follow-up.
Thank you. And the status of this witness?
I would ask that she be constructively sequestered and subject to recall.
No objection to that, ma'am.
Okay. So, Ms. Foster, what that means is they're done with their testimony for now. They may recall you to come back to the witness stand, but you don't have to physically stay in the building.
Okay.
So you may leave the building. Just make sure that the contact information is good. So if they need to recall you as a witness, they can. You cannot stay in the courtroom, and you cannot discuss the case until it's over.
And does that mean for the remainder of the trial?
For the remainder of this criminal trial, until this trial is concluded, you cannot discuss your testimony. You are a sequestered witness, but we are not going to require you to remain in the witness room. So you can go about your day and be available if we need to call you back. And they'll let you know when the trial is ended in case. So with that, when your sequestration ends.
Okay.
All right. Thank you very much. And at this time, can we break for lunch?
Yes, Your Honor.
Yes, ma'am.
All right. And so it is 1:05.
Judge, can we let the witness?
Yeah, okay.
Yes.
Come on down while I'm talking. So we'll break for lunch. Is there any motions that we need to take up? I'm trying to time when the jury should come back.
No, from the Commonwealth.
None from the defense.
So they're in recess. Yay. Lunchtime. We're going to take the lunch as well, and I'm building the portal as we speak, so we can come back. We are on catch up. This happened yesterday, so I apologize. We will be getting caught up as quick as we can. Hopefully by tomorrow we'll be all caught up. As things are going on there. Just one second here. Let me get the new video positioned correctly. Get it situated. That's the word we're going to use for today. Situated. Learned that one yesterday. There's our thumbnail. Save. Go back over here. And link to this one. And there it is. I might have done this a time or two. You'd never know. All right. There we go. What a morning. What a morning. Hey. Look, I leave mod chat on the screen, and they're sending me scary ghost pictures to try to teach me not to leave mod chat on the screen. All right. I understand. I should do better. We're going to have a little bit of a lunch break. When we come back, we're going to continue today, what happened the rest of yesterday and some of today. And they're just at lunch right now, that's all. Just at lunch. Tonight, when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. Please stay safe. We go live again in about an hour. How does that work? 2:15? A little under an hour. We'll be back for more of that. Was Boyd guilty yesterday? Yes, you guys missed it. We did come live again yesterday with Judge Boyd and the guilty verdict. We have not followed the sentencing portion yet. I haven't even checked to see if that happened yet. But the jury is going to choose the sentence as well. We'll see what happens there. We'll try to bring that to you if we have time. But we're on catch up, so priorities first right here. And get some lunch. Do something amazing. And we'll see you in a few minutes. Bye-bye.